Any original side mentioning? Item number 1.
Yes, sir.
But the question is cropped up for consideration before the lordship. Regarding non-issuance of or non-completion of the order under section C1 of the Act of 1948.
Yes. The Requisition Act. Requisition and Acquisition.
Yes, Act of 1948.
এটা কি এটা মধ্যে
না আমার প্রচন্ড বিশ্বাস
yes yes
at this happen you will look at take up section 3:1
yes
if the state government C1 if the state government is of the opinion that it is necessary so to do for maintaining supplies of service essential to the life of the community of the increasing employment opportunities for the people by establishing the commercial estates and industrial estates in different areas of providing proper facilities of transport, communication, irrigation or drainage for creation of better living conditions in rural or urban areas.
Let us come to the end. The state government may by order in writing.
Yes. The state government may by order in writing requisition any land and make such further orders as appear to be necessary precedent in connection with the requisitioning where no land is so first is the order required to be passed by the state. Next 2 an order under subsection 1 shall be served in the prescribed manner on the owners of the land and where the order relates to land in occupation of an occupier not being the owner of the land also on such occupier. So my lord, first is the satisfaction of the state regarding the requisition for that an order required to be passed. After that, that order required to be served upon the occupier of the owner. My lord, can you consider here this is specifically mentioned the owner and not the occupier. Now my lord, how it will be served that is also there. My lord, can you turn to rules. What's the land requisition acquisition rules? Rule 4. My lord, it will be find in the back side.
Rule 4. Rule 4.
Rule 4. The orders under subsection 1 of section 3 will not be found. And subsection 3 of section 6 shall be respectively as nearly possible in form 1 and 5 appended to these rules. And the notices referred to in subsection 1 and 3 of the section 5 of subsection 3 of section 6 shall respectively be as nearly as possible in form 3, 4, 6 appended to this rule. The notice referred to in subsection 1A of section shall be nearly possible. A notice on the subsection next one 5 says subsection 3 of section 5 order under subsection 1 of section 6 shall be served in the manner as provided in clause A of rule 3 of service and order under section 1 of section 3. Now, my pause here for a moment and Mother can turn to rule 3 1 and before that by delivering or tendering a copy thereof endorsed either by the person authorized by the act to make the order or by the collector to the person to whom the orders to be served or his agent by fixing a copy thereof on the outer door of the subconspicuous part of the house in which the person or whom the order is to be served, but it decides that carries the business of personal works for gain or by sending the same to the person or whom the order is to be served by registered post to the account due or by fixing such as such. So, my lord, A is mandatory. B, C, and D are the option. Either or.
Well, all are all.
You're not fine.
All are all.
Or.
All are all.
All are all. But there are not logically. If delivery tendering a copy once, if it is tendered, but there is no other option.
No, if it's an optional thing, I mean, all are optional. So either of the
any of the one of the one required to
They can directly fix without search data.
Yes. So, argument is advancement.
Learn it.
Order. Even optically can't
Advanced by learn it.
advocate general. Like we should
Yeah, advocate general can also be a friend.
It's our duty to honor the chair.
Absolutely.
Don't make the advocate general friendless.
No, it's after privilege.
That is a professional hazard you suffer. Yes.
Now, my lord, can you take the volume 1 once? No, my lord, directly.
Volume 1 of the G, of course.
Yeah.
Yes.
That you notice community the order was ever served upon either to the owner or the occupier. This was my specific stand taken in my application also. The basis of such stand, my lord, eliminates from the
You are an owner or occupier?
I'm the owner. If your lordship is kind enough to turn page 51.
50.
50, my lord.
Yes.
I wish to show my predecessor name was there, featuring in the record of rights. Only for that purpose I have drawn it. Now, if your lordship can task to page 69 once.
Yes.
I am directed to refer to whom it has been mentioned, my lord. It is my predecessor. And it is in there 1999, my lord, got it. I am directed to refer to your letter that is such and such. Page 69. On such subject mentioned above, and to inform you that all the plots of land in Moja Koshba have been decided to be bought under preliminary notification under section 4 of the Land Division Act 1894 to 1695 for years such and such. Pause there for a moment, my lord. Can you consider what are the plots of land that are involved? CS dark number 3775, 3777, and 3788. These are the 3 plots which are the subject. So even if my lord, can you consider the argument or the stand taken by the state that it was acquired and delivery of possession was delivered in the year sometimes in 1956, 74. Then there is no occasion on the part of the state government for the primary satisfaction.
Please repeat what you said.
That it is the case that 73 this land was acquired.
1973.
Yes, and possession was delivered. That I'll come.
That is the state's case.
The state case. From their opposition, I'll say.
Yes. Yes.
Then if that is so, my lord, can you consider the date where it was mentioned to the my predecessor that they are intended to bring these plots of land within the purview of section 41A. Now, my lord, can you take some space? This is a 2001 publication, my lord, will find by the state. What are the plots involved, my lord, you will also find. These are the 3 plots, and the area as mentioned is the subject matter of acquisition.
We'll get the date. End.
At the
Left. Yes.
legible copy is page 76, 75 is illegible copy is 76, legible copy is 75. 2001. Notice dated 7/2001. My lord, will find. The undersigned is pleased to fully cancel so much of mistake order requisition. There is 73, there is 74 under section 3(1) Municipal Land Division Acquisition Act, which was served upon the interested person between 2/5/1978 to 10/5/1979 to 14/5/79 15/5/1979 to such and such, relating to the plot numbers noted below under this Calcutta. Development.
Whatever, this project.
Fine, these are the three plots. So, my argument stands on the fact, my lord, if in the year 74 it was acquired by publishing the award according to the state, then there is no occasion on the part of the state in the year 2001 for cancellation of the notice in respect of these plots. Those are issued sometimes from 2/5/1978 onwards.
Because your notice was of 1999.
My notice prior to that.
You say no notice was given.
No,
They cite a notice of 1999.
no, they have not cited notice. That is precisely what is.
Where do you get page 69? 69 you place before us.
Yes, 69 is the letter issued by the state. Communicating to my predecessor, they intended to bring notice under section 1A.
That is what we are saying. If 1999 that notice is given, then there could not be before 1980
any acquisition.
vacancy.
That is the precisely the stand taken by the state that the notice was duly issued, revision was done, acquisition was done by Gazette Notice 418, and subsequently it was done within prior to 1934. It is the KMDS letter, well, BS is the revision body. 75 is the state. Well, they are the revision of body, well, they cannot take different styles together because either they are what are they getting to the state. If that is so, I am on better footage.
So your plot, a part of it was cancelled by this.
No, they did. This is the plot supplemental. So if 75 stands, Mala, it is the three plots. Those are in 2001, and they said requisition notice in respect of these plots were served on and from 2/5/78. So the stand taken by the state that prior to 1974 these plots are already happened does not fit with their own communication. So the state is concerned.
So there are two scenarios. One is that no notice was given because 1999 for the first time this proposal was given. This is one aspect of your argument that if 99 is the first notice, then there could not be prior acquisition. Secondly, even if there was prior acquisition, they cite letters between 78 and 80, and that has been cancelled by this.
2001.
By virtue of this cancellation, in any event, then does not remain anything.
So therefore, the stand taken by the state of the opposition and satisfactory lordship, the acquisition notice was issued that acquisition was completed prior to 1974. Does not stand. Now, if your lordship may kindly turn to, though it is there, which they have denied at page 80.
Yes.
The lordship find information, right information. They said that it was personal capacity was issued by the Deputy Secretary, LA Collector under the CMDA, where it says that status of the arrest dog number such and such has been acquired fully by KMDA case number LA2 of 40 of 1974 for the purpose of implementing the various development within the East Calcutta area development project. All these particulars are obtained from the available office records. The first time this came up for consideration in 2007. This was when they hang up a board of Haldirams showing that it was allotted to Haldiram. Now, if your lordship may return to, I came before this honorable court and opposition. Apropos to this, can you consider the opposition the stand taken by the state? Well, this is not compared of the entire thing.
Opposition task.
Yes, yes. Annex.
Opposition application. Yes.
Volume 3, my lord, will find it.
The opposition in the report.
Yes. They also find a supplementary, both are in this.
Which page?
I am drawing lots of attention, so but the opposition. You also can consider page 212. Oh,
This is your reply.
Page 98, volume 2, I forget you, Malak, that is my. Yeah.
Yes.
I say that this is the opposition filed by the state to the land special land acquisition committee. Subject. Yes.
Yes.
98. Sir. I say that since the land has been acquired and possession of
98.
98, my lord, this is the part of paragraph 9 of the opposition. I say that since the land has been acquired and possession has already been handed over to CMDA, at that point of time, the proper compensation has been paid at this stage. The former respondents having no legal right to claim the ownership of land. I further say that the acquisition of the aforesaid land is full and final long back in 1976. On a record that and CMDA taken possession of the land on 18/12/1973. I don't understand. Yes, it can be done because after acquisition it can be handed over. Subsequently, when 419 notice was published and ultimate award was given. And the compensation has been paid to the awardees. There, the communication dated 22nd/11/2007 claimed to be furnished by the public information officer being deposited of the such, having no legality and validity at all. It is a valid document and the said officer supplied the same in his personal capacity without going through the records. And pause there for a moment. This is the letter issued by the KMDA where I have drawn to your 4-day notification will be issued for the purpose that was denied by the state that it is in its personal capacity rather than legal bearing. Can come to next page, page 99.
No, this is the denial of page 80.
Yes, page 80. My lord will consider the volume 1. Deny করলো ওই যে
You placed before us.
Yes, 81. 81 they said initially there is no acquisition.
81 is nothing.
No, that is their public I am not drawing your attention to. There are only letter that which has been issued, but it is said in that manner. We as a malad, I am also keeping the same malad, taking the face value of the
80, 16, 11, 2000.
yes, but that I am drawing your attention that whether those two letters have been denied in that affidavit or not.
No, they deny only this 20.
Yes.
November letter, 23rd.
Yes. There where the communication was made that it has not been affected. Malad means the claim of the petition, Malad will find that India 1970 there is absolute possession of the aforesaid land. The claim of the petition regarding the non-service of notice at the time of acquisition proceeding is not correct. As because the predecessor interest of the petitioner received the compensation of the said suit land. This is the only stand taken, my lord. Now,
No, but in that letter, page 81 refers back to page 80.
yes,
And page 80 is a letter which says that it has been acquired fully in delegate number such and such,
Such and such.
73, 74. So there is no conflict between LAKs being of 73, 74
there is a
and position being taken on 18th of December 1970
yes,
and then acquisition in 1970. That could be.
that
So we
If
don't know
that
why
is so-
they have denied this.
no. Agree.
We don't understand why they deny this. That is what we are saying.
It is there.
Even if that letter was there, I mean, it would not any to your benefit in that. If there was an actual acquisition.
Actual acquisition. I am relying on one the page 75 and precisely by not the earlier communication that is a page 67.
69.
69.
Page 75 says that notices were issued between 78 and 80, which is in contradistinction with their plea that it was done, possession was taken in 1973 and acquisition in 1970.
So even if Marat, it is not the Daya, but the land in question is this
Even if acquisition was in 1976, 78, 80 notice would be.
There is no objective part of the
and page 69 also, because that puts the date even further back.
Further back. So even if Marat, it is a CMD who is the repairing body has no direct.
Whichever, whoever. Both the state and the CMD, their stands are nullified by 69 cents. No,
75.
Page 69 was given by KMD.
KMD.
And page 75 by this.
By the collector. Okay. So this is, it is not a case that a portion of the land delineation by this letter or by this notice. The land which is subject matter application is the image entity 18 kata, 7 acres, 29 square feet, and 29 kata.
That has been cancelled as per this.
As per this. Now I have just taken in the 3-1 notice was duly served, which I have shown to your lordship on the premises that our predecessor has accepted the award.
Page 69 and 75 are the plinths of your arguments, primarily. Already. These letters have been denied. And
that is in their opposition manner.
Page 69 or page 75 letter.
May I read the entire opposition?
So specifically, these letters, that these were not issued or served?
No, only this letter. That is why I precisely
this letter is different.
Different. Apart from this, there.
No, even if this letter is denied, they independently reiterate that in 76 acquisition was taken and possession was taken. So even forgetting that letter of KMD, state stand is that 73 possession and 76.
Ultimate, everything has been over. 73 possession taken, 74 possession handed over.
But they have not denied those 69.
That is why the data which is paragraph 11 page 99 is a specific denial about their own documents. And if your lordship can consider these letters relied upon by us in their read application, paragraph 5, page 34.
You read
in my read application. Now, yes.
Page
34 paragraph. And it's a 34 is a series of letters.
Petition.
It is added.
Volume 1
It's
as if we are hearing the yes.
34 you are occupied.
Yes.
Paragraph 5, the series of letters which have been communicated, P8 collectively. P4 is the communication dated November 22nd, 2007. My lord will find.
Mr. Chatterjee, both of you cannot argue. Take your seat and ask. Yeah. You don't have to prove anything to anybody. Take your seat and ask. It's having for the course.
The copies of the relevant communication. Next page, may I read out for your lordship?
Which page?
Page 34, paragraph 5, preliminary application.
Yes.
The representative for the state investor the land in question. There has been no acquisition proceedings pending. Although in the past the state government has alleged that certain acquisition proceedings under the Land Acquisition Act has commenced. However, inquiries made by a petition clearly established that no such proceedings whatsoever now pending in respect of the state property. In the other words, according to the provisions of the law regarding acquisition, after the expiry of 2 years of the date of commencement of such proceedings, the existence of have historically evaporated. As for the completion of such proceedings are concerned, Office of Relevant Communication that are issued by the concerned LA Acquisition Department to the state of West Bengal are annexed here to and marked with letter P4. A communication dated 22nd November 2000, the petitioner informed by the public information officer, which contained a report of deputy secretary such and such. The respondent number 3 saying the concerned land was acquired in 1973-74 for implementation of the certain development works by East Kolkata Area Development Project. The state information beyond all disputes is correct, as well as appear from the Kolkata Gazette issued by the government dated 8 December 1983. In this context, a petition of the court ordered the survey done from the land acquisition authority, including the report dated 7 July 2001.
P4 is which page?
Yes.
P4?
Yes. Before your working time, page 67.
Page 69 comes within P4.
Yes. Up to page 35. And applicable to this further qualification, they have replied to for this. That you will find page 97. Paragraph 9.
That is that paragraph which you.
Yes, 4 and 5 have to be. Where you are find only so for the letters and documents are concerned, nothing has to be done.
Yes.
Now, what stand they have taken for the purpose of showing the issuance of notice? The claim of the petitioner, page 99, paragraph 11, last 4 lines of the first said paragraph. The claim of the petitioner regarding non-service of notice at the time of acquisition proceeding is not correct, because the petitioner in case of the petitioner received the compensation.
Any receipt regarding compensation or anything?
That I'll come, my lord. So these are the stand taken. Now, my lord, when he was directed to produce the documents in respect of the proceeding 3-1 notice, now they have volume 3, my lord, I turn to page 36.
Volume 3 page?
269. And if you I turn to page 69. When after the query made by the Honorable Single Court, Judge, they filed a supplementary affidavit disclosing the notice communicating the order under section 3.1.
This is supplementary affidavit of state.
State, filed before the Honorable Single.
Yes.
I turn to paragraph 5. Page 271.
Pagination is not there, internal page you can see. Only page is not paginated up to 69.
Internal page 5.
5 you have found out paragraph 5, yes.
That time we having the same as the point has been raised regarding relating to absence of the said notice under section 1 of 3, this annexed. So now I will next minus 274. Who is there
Not
produced?
paginated.
Page 7, page 7, I forgive you, madam.
All right, yes.
This was produced. Such and such, and was the governor. Now hereby in exercise or conferred under subsection 3, 1 of section 3, the West Bengal Land Acquisition Act. Deed over an authority vested to me and to have acquisition the land. Now here conspicuously these are the notice according to them which has been issued by them for the purpose of showing compliance of section 3, subsection 1 and subsection 2. 3.1 is the order, 2 is the communication. My lord, here versus conspicuously, my lord, to whom it was issued, nothing has been found out. And who have issued, that is also there, not there. I satisfy your lordship that compliance of 3.2
So you say there is no proof of service.
There is no proof of service, service to be done to the person interested.
You say there is no proof of service.
Proof of service. Not even whether this is a notice getting compliance of 3.2 or not. Because your lordship, what requires for the purpose of satisfaction of 3.2.
So this could be addressed 3.1 compliance.
And
Order
best
is passed,
order is passed.
but no service under
Yes.
two.
Because page 7 at the bottom, my lord, will find why this copy 2 was mentioned. And what is the reason for holding this act to be intravirus? Because this is the place of everything that you have to serve notice upon the owners or the occupiers indicating the land which is subject matter requisition. Because in the statute, I will suggest your lordship, there is no provision for personal hearing, save and except this communication of section 3, subsection under section 3 and subsection 2. 4.1 is the public communication by official gazette. So this came up for consideration of the Honorable Apex Court. Regarding challenging the virus of this act, and for this purpose, I am going to listen to the Honorable Apex Court while deciding this issue. Only this portion, 1971, yes, 71, 91. 71 to name.
Yes.
I will find paragraph 7.
No, until you reply, they had given their reply.
I have requested.
Just writing a new judgment.
No, he does. I had a talk with his friend. I had an impression the application taken up application for as my lord is taking whether I have requested.
So we'll give Mr. Datto
Yes,
right to reply to this.
Yes, actually all everything. And yes, this is a failure that allowed me that.
Yes.
That is why, my lord. One can turn to paragraph 3, my lord. In order to appreciate the points as well under council, it is necessary to set up the schemes of the act. The Influent Act was enacted for providing efficient of the speedy acquisition of the for a number of public purposes. The purposes are manner it was mentioned. After that, you will also find service in order to prescribe manner. Authorized by the state government on this behalf may exercise within the jurisdiction of the powers efficient conferred under subsection 1 of subsection 2. Section 3 provides for service of this order in the prescribed manner on the owner of the land and also on the occupier, not being the owner of the land. Under subsection 3 of section 3, the collector or reaper authorized by him in writing in this behalf is entitled to execute the order in the manner therefore therein. If the order passed on subsection 2 is not complied with by any person, there is nothing in the imperative which prevents a person or whom an order has been served under subsection 2 to make a representation to the collector of the state government against the order regulation. Section 4 enables the state government to use the land with the land for the aforesaid purpose. Why I am drawing attention only on the ground? Because this is the only provision under the statute that I can raise objection. This is not a public purpose. Akin to minor Calic Hospital, the section 6 of the Land Acquisition Act, where before the notification, the objection was invited. I have to file my objection. If they are satisfied with that, yes, this is not for the public purpose, they can receive or recall the intent notification. Now one can turn to paragraph 9. We are therefore, my lord, defined of the opinion that it is difficult to hold that restriction imposed by an impugned act are unreasonable. Fair compensation has been provided for revision, which is determined by the civil court and ultimately by high court or the Supreme Court. Regarding the necessity for revision is not necessarily left to the state government. It is true that there is no express provision to make representation against the order of revision, but there is no bar to representation being made after an order is served under section 6 subsection 2 of the Act. We have no doubt that if the representation is the point such overrides the public purpose, it would be favorably considered by the state government and other government authorities as the case may be. So, for the purpose of issuance of section 4.1a, the communication of the section 3 subsection 2 is mandatory. And this is on the basis of the reference made by the before the larger bench. That your lordship find. The following review question has been referred to constitutional bench under provision of Article 140. Therefore, the Honorable Apex Court while holding this statute is intravenous based on the fact that after issuance of notice under section 3(2), we have a right of raise objection. So if there is no communication on the
Not
part,
a right. Nothing prevents you. I mean, there is nothing to prevent you from doing it. Because the language of this judgment is, Mr. Rai, that it is true that that there is no express provision to make a representation against an order. But there is no bar to a representation being made after an order is served.
yes,
This is
there
the
are-
language.
after the issuance of the
No
notice,
express provision to make a representation means you don't have a right,
right?
but there is no bar.
Yes.
But even that is taken away if no notice is given. So by implication, this was the ground that you, in any event, you have a right of representation, but you say that is taken away in this present.
Why not issuing notice? Because after 3(2) notice was issued, an order was communicated to me, I have a right of election.
It's not stated in this judgment in so many words that
But-
notice is so mandatory that it would
Yeah, that came up
Here-
for sessions of civil
show
level.
us that.
And page 8, my lord, your lordship, once my lord. 7 is the format which is given.
That right.
So, my lord, page internal page 7 of the
Of what?
opposition supplementary evidence we have shown to you that's the format section 3. Next page is the schedule of lands. Schedule of lands, these are all the symptoms subject matter recreation. And it is not related to only to my land. The commission to paragraph 20.
20?
21, paragraph 21. It goes on to provide melody line. 21.
Yes. Yes.
In section 3, subsection 2, melody line. Paragraph 21. Of that act that an order under subsection 1 shall be served in the prescribed manner on the owner of the land, and where the order relates to land in occupation of an occupier not being the owners of the land, also on such occupiers. It is also appears from the said provision. It does not require notice to be given to the owner or occupier before the order of acquisition is made. Although it requires that the order of acquisition after having been made shall be served in prescribed manner on the owner and the occupier of the land. It is contained, my lord. These are the things one I am skipping over, my lord. Now, my lord, I am going to the alternate option. Now, my lord, you are looking at page 46 once. Paragraph 46.
Yes.
The next challenge to the order of deviation is that it is valid, I am to give no time or hardly any time to the appellants. The argument of the appellants is advanced on the following lines. The impugned order is dated 5th November 1969. The order itself delivered served on 7th November 1969, calling upon the appellants to deliver position on the very day following the following. The appellants contended that there is grossly insufficient notice as such the order should have been struck down. Very far instance C1 as quoted above does not speak of any notice whatever. The section provides in section 3 subsection 2 that the order shall be served in the prescribed manner on the owner occupier of the land. That has been done. The statute therefore does not provide any particular notice or many minimum period of notice. The requisition and the requirements of section 3 subsection 2 of the West Bengal Act have on the facts of this case have been satisfied. No question of any notice or reasonableness of period of notice of the circumstance can arise. The owner or occupier of a land whom the order requisition has been served under section 3 subsection 2 of the is expected to know that he is required to deliver that order. So the requirements that you done is section service of notice.
Yeah, the question was insufficient time given.
Yes.
The court held lastly held that in any event this consideration cannot in our judgment vitiate the order of requisition, but in the facts of the case,
Yes.
and on the terms of the statute.
Because the court
Insufficient notice cannot vitiate. This is not a precedent for the proposition that notice is mandatory. They took a point, this particular person took a point that insufficient time was given. Court said that no particular time limit. So this question does not bother the court. It does not vitiate the order of requisition.
Because C2 has been complied with. Why did not vitiate it? Because C2 has been complied with. So therefore there is no other occasion any notice you get to be served at the time has been given.
And if you come to page para 32 of this judgment, that is internal page, the page 13.
Yes, ma'am.
Just immediately above para 33.
Yes, ma'am.
Upon consideration of the LA Act and 50 years passed in between, we have read these paragraphs also in the meantime. So after 50 years have passed after LA Act, and on a consideration of all the acts, it stated the general conclusion that follows from this comparative analysis and contrast of these two acts is that no construction should be placed on the 48 Act, which will stifle or impede the main declared object of requisition and speedy acquisition of land.
Yes, yes.
So this has to be at the on the background, behind our mind.
Yes.
So this should be the yardstick of
For the purpose
interpretation.
why not can you consider it is only for the time frame. When the
No, para 32 was not on the time frame. This is the general conclusion.
Yes.
That this act has to be interpreted in a particular manner that will not stifle or impede the main declared object of speedy acquisition.
So therefore, why not the requisition of the power has been given?
Even in this judgment, Mr. Rai, it's not categorically held that mandatory, the notice will be mandatory, and even if it's not mandatory, it will not. It does not say it will vitiate the entire process of requisition. And it's also well settled, you know, Mr. Rai, that a judgment is a precedent only for what it holds on the facts of the case, not what can be derived or analyzed from that proposition.
Yes.
So you are deriving something which is not laid down in detail.
So
that this is held as a logical corollary. Logical corollaries cannot be looked into while taking as a precedent. So neither of the judgments hold that it's mandatory, but yes, you have a point in what you are saying. That the general presumption was that 3-2 notice is provided, therefore act is intra vires, and 3-2 notice under in any event, even if there is a little time gap, you get an opportunity. So opportunity was highlighted in both the judgments.
Yes.
You understand that?
Now, same question from Madam. What is followed from the lordship?
Why don't you cite it before it falls from us? Cite the base judgments first.
Yes.
Always cite the base judgments first. They ask
first
questions, you reply, and already our mind is made up. Then you cite the last judgment when our mind is already made up. So it's better to start from the base judgment and go to the ancillary ones.
Yes. Paragraph 8, Madam.
Give the citation for Mr.
Yes.
For learned advocate.
97, 1,
97 160. Para?
Paragraph 8 and 9. In view of the aforementioned liable condition, 3 questions arises for consideration in this appeal.
Yes.
Whether the entire declared
cite this
proceedings is vitiated in law, going to non-service of notice upon the petitioners. whether the purported order that is is valid in the eye of in law, and whether the judgment of the learned trial judge can be upheld by reasoning of subsequent events as stated by the respondent housing board in affidavit of opposition to stay application. The said act was enacted to provide for requisition and speedy acquisition of the land for certain purpose. It is not in dispute that the requisition of the joint owners of the land in question. It is also not in dispute in terms of the provision of section 3 subsection 2 of the said act. The lead petitioners were entitled to a notice of requisition subsection 2 of section 3 of the said act. Provides that an order under subsection 1 of the said act shall be served in the prescribed manner on the owners of the land and where the other relates to land in occupation of an occupier, not being the owner of the land. Also on such occupier. It has not been disputed for us that subsection 2 of section 3 of the act is mandatory in nature. Inasmuch, if a owner or occupier such land, as the case may be fails to comply with an order mandated under subsection 1, the same shall be executed by the collector in such manner as he may consider expedient, and for that purpose may take recourse to one of the other modes of execution as specified in subsection 3 of section 3 of the said act. It is therefore clear that on the respondents on showing the principle of natural justice is not required to comply in such and such. This court has held that keeping in view of the fact of the principle of natural justice are not required to comply with, the requisitioning authority must strictly comply with the mandatory requirements of provision of Act subsection 2 of section 3 provides that that an order shall be served in the prescribed manner. The word prescribed has been defined in section 2C to mean prescribed by rules made under the said act. The state government exercises power conferred section 13 of the said act to make rules, and the said rules known as the original land division and acquisition rules. One of the rules 3 has been quoted. Next paragraph 10 madam. It is therefore evident that in terms of subsection 2, section 3, the said act notice are required to be served in terms of provision of section rule 3. Aforementioned, in terms of the aforementioned provisions, notice is required to be sent by registered post as on due. There is thus no provision sending a copy of the order under certificate of posting. Subrule D of rule 3 of the said rules provide that an order may be served by fixing a copy thereof in some conspicuous part of the land to which the order relates, as also in conspicuous place of the office of the collector. Admittedly, no notice was affixed in some conspicuous place of the office of the collector. The word "and" used in subrule D or rule C must be held to be conjunctive and not disjunctive. In recent decision, just quoted, this bench held it is not in dispute the notice of a landowner or the occupier is mandatorily required to be served before the possession of the land in question is taken. Reference to the question of as well the recent decision being judgment has been quoted. After that, it is admitted there was the possession of the land in question was taken over in 7182. The copy of the notice was served on the petition only on 24/3/83. It is the view of the matter. There cannot be any doubt whatsoever the entire proceedings was vitiated in law. Apart from that, Rule 3 has not been complied strictly. The very fact of possession of the land was taken on 14th May 1984, and a copy of the notice was served upon the petitioner number 2 on 23rd May 1984. In our opinion, we amount to non-compliance with the mandatory provisions of section 2 of section 3 of the said act. Mr. Sajanset himself has indicated here has replied upon the decision of the Supreme Court decision Sajanset, wherein the Apex Court relied upon the decision of the Privy Council. Here, though it is permissible for a tribunal to accept a part or reject the rest as a witness testimony, so far an admission in pleadings concerned, it cannot be so rejected. It may be accepted as a whole or not at all. The said decision, therefore, instead of helping such and such, supports the contention of the petitioners. Because the order should be served upon the occupier, it has to be given jail principle of constitutional law, it is considered the paragraph 12. From the record, it appears that two orders have been issued by the collector. It appears from page 26 of volume 1 of the paper book, which interior contains the plot in question, namely plot number 1788 measuring 18 decimal. However, appears from the another order was passed by the collector, which contains the details of the 20 plots. Although the numbers of both the cases being revision case number such and such is the same. It is not been explained before us how and what under what circumstances two different orders were passed on the same day in different proceedings. Furthermore, from the same order it appears that according to the opinion of the collector, the order of requisition was required to be made. It is necessary for purpose of maintaining supplies and services essential to the life of the community, namely for implementation of the housing project and at Monot. In our considered opinion, the finding of the learned trial judge cannot be sustained for more than one reason. In terms of subsection 1, section 3 of the said act, which confers power of the requisition of the state government, apart from maintaining supplies and services of essential life and community, another purpose mainly for creation of better living conditions for urban areas, has been mentioned. A housing project is undertaken for the creation of better living conditions in rural areas. Monot is the rural area. Thus, a housing project rural area could not have been undertaken for the creation of better living conditions of the public. If such project, in our opinion, would come to a purview of public power, namely service essential to the life of the community. The what service essential life, it is considered after that. Similar, it is now well known, for the middle portion, that the statute should be read as a whole. Subsection 1 of section 3 of the said act specifies various public purpose.
May I have you for 5 minutes?
Yes, yes.
This various public purpose. This cannot be
Go
any
further. Up to 11.
up to
11 up to 11 it said must be served upon the owner.
and when it provided. Ultimately, it was the entire proceedings was pushed first.
But other points were also there.
Also
There
considered.
is a difficulty in judgment of this particular. Now we lose the track. I mean, whatever the question
Because there are-
consideration something else that is not decided conclusively. Several judgments are recorded where this has been held. So we have to go by those
It is
judgments.
not judgment,
Here nothing has been held. It goes on a different footing.
but
Several multiple orders were passed which are contradictory on which ground it was satisfied. But here these propositions are discussed, which were laid down in previous judgment.
Yes, and those judgments why not we find from this judgment?
Yes.
And
Particularly para 9, when it says the requisition authority must strictly comply with the mandatory requirements, which provides that an order shall be served in the prescribed manner.
Yes.
And para 11, where it says Justice Sobhushaj Mukherjee's judgment in Taraknath Sen's case says categorically held that must be order of requisition must be served.
Because it has consequences effect. Because non-compliance of the said enables the collector to take position. So without service of notice of the order under 3 subsection 2, there cannot be.
Good.
Now, my lord, why I am citing this judgment, my lord, I have to put to this, my lord. The notice must include the plots of land which I require to be handed to the owner or occupier.
Those were not
Nothing.
in the supplementary duty.
Nothing. All the plots have been mentioned. It is from which schedule? Nobody knows. We as it may, my lord, on the earlier occasion, I have satisfied your lordship that it cannot be because at the relevant
So schedule may be seen on the reverse for all the plots.
all the plots.
But then all the plots, entire, it's written entire.
6 plots. That is
Yours are 3797.
no. 3775 and 3788.
3788.
Yes. And the bottom line will be 5.
Yes. So in all these 3 plots, it's written entire.
Enter.
So the entire plot then.
The other plots I have to because my lord, it is a notice.
You are concerned with 3775, 3777, and 3788. All these are mentioned here and written entire, giving the entire area.
So it is the
So as far as you are concerned, there cannot be any doubt.
no.
If notice was served, of course.
If it is the third order, it should be indicated the land from which I have to. It is not the entirety critical to be served. It is by indicating the land from which I have to give position. And to mention that is why it is a
If the entire plot is requisitioned, then where is the
There
question?
is indication you can give it. There is no indication. That's why what they are saying
It's
is
indicated entire.
no. This is a schedule has been mentioned, but not subsequently. It is not in the order of the notice.
Need not be. It refers to the schedule.
It might not be required. Well, that is why. Well, at the bottom you will find.
Schedule may please be seen on the reverse. The order itself says numerical 1 at the end to take possession of the lands as described in the schedule.
Yes.
Schedule under schedule it's written may please be seen on the reverse. Reverse page schedule is given and it includes your entire 3 plots. Where is the dilemma? I mean,
Yes,
where is the
because
ambiguity about it?
The ambiguity will not depend on schedule. In a notice for requisition must be served from the owner from the
Service is different. We are
no
agreeing.
indicating my lord to whom it has been served.
Service we are saying yes.
And also
But this order is a complete order.
Order is complete, my lord. This is 3-1. I am not disputing.
3-1 not only 3-1 categorically indicates that your entire 3 plots have been taken.
Yes. Apart from so therefore, my lord, if
your argument is regarding service of notice.
Yes, and including that the portion regarding satisfaction because this schedule which has been mentioned to your lordship find at the bottom which I have drawn your lordship attention at the bottom of the schedule.
Yes.
Your lordship find that is signed by somebody else, but the 3 persons cannot be signed as a schedule of the. It cannot be issued in that manner. It is a collector, ADF, or the first one is the 3.
Is it not signed? Unsigned?
No, first is unsigned. First page is unsigned. And the next page, all cannot issue this. They cannot exercise power. Only that is why, my lord.
But can superfluity make render a notice order redundant?
Yeah, if the collector is exercising power, then the ADF has not the jurisdiction.
It is superfluous. Like for misjoinder, a suit is not dismissed. For non-joinder, a suit can be dismissed. If the collector did not sign, then we understand. If the collector and his cousin and his Ardali all sign it, if the collector's signature is there, it's a valid notice. All else is superfluity.
Then that is why, my lord, if it can be supposed that the previous order was passed by the collector under his signature.
Collector's signature is there.
No, subject to question in the notice.
Come to page 8.
Yes, my lord.
Collector's signature.
Initial 7.
Anyway, the schedule is the end of the notice.
Which is the order regarding this subject to question, my lord?
Order, schedule is a part of the order. Schedule has been made a part of the order, right? Because the schedule says to take possession of land as described in the schedule. Schedule says maybe please seen on the reverse. And then you are right, there is a place for signature there which is left blank.
And also copy 2.
Copy 2 is very important.
Yes,
Copy 2 is a notice.
Yes.
We are agreeing with you that that's what we say.
Oh, yes. Sorry. No, no, going to one corner. There's a you logically consider 274. Well, in a number 7 of the form. Why this? As a that this is a format which has been used to take copy to and of the land described in the schedule to the above order. One will find that was the printed form which they usually use for the purpose of requisition.
Copy 2, yes.
And the bottom I will find.
Yes.
So therefore, here your lordship will not find in the order, if it is the order passed under section 3 subsection 1, it does not say that this schedule which has been appended subsequent to the is the subject matter application pursuant to this order.
You don't understand.
Yes, if your schedule maybe please be seen on the reverse. My lord is looking at the schedule portion.
Start from para 1 before that.
Yes. And whereas the governor.
No. Second, next.
Now, therefore, in exercise power.
Now, therefore, in exercise power conferred under subsection 1 of
section 3.
Yes, I do hereby requisition the lands mentioned in the schedule below and make the following further orders, namely 1 to take possession of the lands prescribed in the schedule by such and such, and then plan.
Yes.
Then the schedule is given. Schedule says may please be seen on the reverse. The reverse is included in the schedule. and schedule has been included in the order itself to be a part of the order. The order says, conferred by subsection 1, I do hereby requisition the lands. Which lands? Mentioned in the schedule below. Schedule says go to the reverse.
So it can be done. What is fundamental?
So that schedule is made incorporated into the order by saying I requisition the lands in the schedule, and schedule is on the next page.
So this is an order.
So the entire thing has to be read as the order.
So this is an order at best.
Notice copy to is blank, and there is no further proof that it was served or affixed or no averment even.
And that is why I don't know.
So there is a distinction between the order being invalid and the notice there being 3-1 and 3-2. 3-1 we find, yes, you have a point in saying that the main page of the order is left unsigned and 3 persons sign on the rest, which creates a doubt.
3-1 also might not even logically consider. The judgment said the 3-1 you have to say that this plots a revision. Unless, yes, unless until I complied with the direction for handing over position.
Does not mean it has to be in the first page of the order.
No. That is the statute itself said, Bernard.
Yes,
included. The satisfaction of the authority
included.
Yeah. They have to direct me and see to that when I have to hand over position.
So you started your argument like the judgment we said, now you are losing track. 3-2 we are prima facie satisfied. We'll come to that later.
Yes.
But 3-1 you are saying that is also vitiated. How?
Yes.
We find 3-1 to be satisfied.
3-1 this is revision, this is made and the lands has been mentioned in the
Why do you say 3-1 is also not satisfied?
Yes. You are not concerned, they are only required to be made that these are the land which is required for the purpose of liquidation. Then the notice will be issued to hand over position of the land in question. After that, the collector can take position of the same. Here, why not even logically consider the notice itself at the bottom? Skipping over the said provision, it was directed that such and such land will be taken over by that. Even logically takes over that once, my lord.
3-1 says, Mr. Rai,
yes,
the state government may, by order in writing, requisition any land
yes,
and may make such further orders as appear to it to be necessary or expedient in connection with the requisition.
Yes, so this is requisition.
This much, nothing.
Yes.
It has to mention in writing requisition. It has to say which land is being requisitioned.
Yes.
And may make such further orders. Here it is stated that I am requisitioning these lands.
Yes.
And further order to take possession of those.
Yes, that can be done only upon compliance of 3-2. That is why, if you logically consider 3-2 once. 3-1 cannot be invoked at that similar. Any order subsequent.
How can 3-1 be after 3-2? Once 3-1 is passed,
yes,
then that is served.
In 3-1, there cannot be any direction for handing over position.
Why can't? Because it says yes. Requisition any land and may make such further orders as appear to be necessary or expedient in connection with the requisitioning. Requisitioning is taking over possession. No, they say I am requisitioning this land, that itself means I am taking possession. Requisition, what does requisition mean?
Because after requisition is I am taking over possession of the land in question,
yes,
and for that physical possession has to be delivered.
The expression requisition itself includes taking over possession.
Then what section 3, subsection 3, you can consider that. Any person fails to comply with an order made under subsection 1.
Yes.
The collector or any person authorized by him writing in this behalf shall execute the order.
That is the execution stage.
Yes. Here one can consider the bottom to whom it is written to deliver. It take possession of the same.
So where is the non-compliance of 3-1?
3-1.
You still don't understand.
3-1. This cannot be an order under section 3-1 simpliciter.
There are 3 stages, Mr. Let us understand this properly. Section 3 has 3 stages as enumerated in each of the subsections. 3-1 is an order has to be passed. The state government may, by order in writing, if it is satisfied on the other things, may, by order in writing, requisition any land and may make such further order as it appears to be necessary or expedient in connection with the requisition. In this order, the state government says, I do hereby requisition the lands mentioned in such and such, and secondly, to take possession of the land as described in the schedule. So this covers one fully. One is satisfied. You are saying one is also not properly satisfied. You don't understand that.
Yes.
Then 2 comes.
Yes.
That order shall be served in the prescribed manner on the owner and occupier. If you don't comply despite that, 3 comes. Yes. It will be executed in the manner provided. These are the 3 stages.
3 stages, Now, my lord, here, my lord,
This is the order.
if this is the
The
order,
3-1 is complied.
yes,
Apart
then,
from the signature.
then, my lord, there is no occasion on the part of the authority to issue the direction for taking of possession by a person in compliance of section 3, subsection 3. At the bottom, my lord, you will find. If there is not compliance under section 3.2,
So
then
you say this is going a step further
further
and usurping the power of 3.
3.
All right. Very good.
देखिए
Very good. Yes. Yes.
now my lord, another argument which might have been argued by the state that that there is discrepancy in the name of the record of rights. My lord, find there is 2 records of rights are there. From where you not will find not this is the name of featuring the record of rights which has been filed by us, and subsequently the state government come up with a record of rights which somebody's names are there. I draw your attention to the proceedings initiated with the state also relied upon 44(2)A proceedings, where it says that the record of rights which has been prepared by the state or not prepared by us, which produced by the state has some discrepancy. That portion I want to draw your attention that you will not find at page volume 3. Volume 3 page 1. These are so much publications taken by the authority, my lord. There is discrepancy in the name of the person. Apart from that, there is no iota of evidence either in the application or supplementary evidence or in opposition that the notice was served in terms of the rules as on this day.
Now, what was this? This is an order under 44(2)A.
2A, because the discrepancy in the record of rights, we have produced a copy of the record of rights from where our predecessor name was featuring. Let's produce a record of rights where the receiver name was recorded as a superior landlord.
Who produced that? They.
They state. What would be a position? How a receiver name can be featuring as a superior landlord? That question then
So how does that help you, Mr. Rat?
because they might say that our name was not recorded in the record of rights. That is why I am
No, they cannot probably say that, because if they say that, then where is the question of any 3-1 notice to you?
yes. No, they said, and that is why the honorable single judge has said there is a disputed question of title. I will not go into the fact. In one hand, the learned honorable single judge said there is disputed question of title. I will not interpret the writ application. Second says they said that you have failed to prove your title, so I will not interpret. So these are the 2 things. One
Yes.
and
Even if you address justice,
no.
brother, I'll go on asking the question. And maybe he will also start asking questions.
We are there, we are at the receiving end, man.
Nobody is at we are always at the receiving end. We have to receive without choice. Captive audience, do you know the concept of captive audience? We are captive audience. We cannot leave the seat. You can leave and go out by throwing your brief, whatever may be the consequences. That is done sometimes. Yes.
Page 24. My lord, your lordship fine.
Page 157 you have seen?
Yes, page 157, your lordship fine. And ultimately, my lord, the portion which I have drawn attention because the
Which page?
page. Yes, our name is also appearing. And I turn to page 167 once. The middle portion, your lordship fine. Our name was appearing. Prabhu Lokumari Dotto. Right hand.
You have marked it on the last.
Yes, that portion only for the bottom of the
No, you were right.
Having a fresh color, that is why I have
True.
this is. Ramlal হতে পারে 170 and 170 bottom my lord will find Ramlal your last line my lord but careful scrutiny my lord will find the Khatian discloses that Ramlal Mondal was a receiver of the rent receiving interest of subordinate to R.S. Khatian number 30. No reasons appear to have been admitted to recording 1600 share in favor of Ramlal Mondal, so the tenancy deemed to have been owned by the receiver for realization of the rent from the subordinate tenants. Dwelling date of vesting. The R.S. Khatian number 7, same Moza was recorded in favor of Water Properties Limited, who was also the proprietor of the entire estate with the Khatian was owned by the Janta. But then there is a vesting of 4.98. So there. The error apparent to have been some error apparent on RS of success. Only for the disputing that what they have said that it cannot be done. The receiver cannot be the superior learner under any event. And one thing, my lord, page 102. And one thing I also draw your attention, page 102 once.
Yes, 102.
The position notice. You will find the process was initiated in rest of the canister port, CS plots. All will find. Moja, such and such. Ultimately, my lord, next page you will find in the position was considering.
These are their documents.
It is there. Then
the position was taken, therefore.
This is the credential, indicating the credential plot.
Yes.
But what I will say is, I think this one,
Yes.
in the CS economics, our name was there, admittedly.
Right.
Subsequently, in the RS one, these two defective records come forward. So even if they come and say that we do not know who was in position or who was the owner, then also it will not suffice because in CS plots, in the rest of this plots, our name was there, my predecessor name was there in the CS record of rights. Not the predecessor, my predecessor's name.
Yeah.
So in any event, they cannot say that we do not know who are the owners or how they came.
If there is no doubt that position was taken, sir, right?
Yes.
You are admitting that position
No,
was taken.
still with remains with that, but the board has been handled. It is a vacant plan. As of this,
Sort of constructive position.
yeah, they might say, but I have said I am physical position. BSP, once they have produced the document, it presupposes that the position remains with them. It presupposes. But actually, in my interpretation, I have stated that I am in position when they hung up that board of Haldiram, then my lord, my knowledge came and I inquired and filed this application. Now, interestingly, the KMD also is a suit filed by Haldiram. I have admitted that acquisition process is not yet been completed. That here, lordship, right? Yes,
What is that?
Article page 1 of Volume 3. These are suit filed by Hodiram. Here's the
This
KMDA
is a
and
deed of
also
license. 221 is a deed of license.
volume
Volume 3, page 221.
224. Wait. Suit filed by Hodiram against the state. I am very lost and this is only because the difference of the
Holdiram is
they are whom they have now license have been granted by
KMD has
KMDA.
given license. So this is Holdiram versus KMD.
KMDA.
It was forgotten.
Yes,
Declared for-
and so the portion where the
Yeah.
benefit is there, that the state, the KMDA says there is no valid application at that point of time. See. The defendant entered into Article 5, 2, 3, 3.
One second.
The defendant entered into
Once. Yes.
The defendant entered into the sexual contest of the same by filing a written statement denying each and every allegation awarded in the plaintiff. Several matters of record. The defense case is that if the suit is not maintainable in as such, same is barred by physical evidence. The defendant has virtually stated in paragraph of his written statement that the defendant authorities informed the plaintiff that the title of the property is yet to be cleared by the land acquisition department as alleged at all. The defendant also denied the allegation that till such clearance is being given, the plot can be registered as licensee deed. The deed will automatically convert into lease prior to grant sublease of the clearance of the title from the land acquisition department. They were informed the pages of the computer of the case has accepted the said deed as submitted on the compartment. So it is in 2009. So according to
But title to the property is yet to be cleared, may mean that the state has not given proper documents in there.
well, so far it is from the
Does not necessarily deny the acquisition. Because it is stated in the carries on the sentence. Said deed will automatically be converted into a lease with power to grant sublease. After clearance of title from the land.
department.
So it may be a wrangle, procedural wrangle in the land acquisition department also. Does not necessarily mean there was no acquisition. Otherwise, there would be no question of Holdiram getting it from KMDA.
So,
So how do you say this is a denial?
So therefore,
the
there is
acquisition?
doubt created. I am on the other side, whether it is the doubt created in the
That is between the acquiring
State.
authority and the.
and the state.
So that does not help you in any way. That does not reshape the acquisition.
No, not of that. Only for the purpose of to satisfy your lordship that they are also in a level that it is not a proper acquisition.
No, they are not saying that. Not saying that at all. Their dispute is post acquisition. Their clearance of title is post acquisition because proper sublease has not been, proper lease deeds have not been executed. Sublease cannot be given, these things. This Mr. Dotto versus Mr. Talukdar.
Yes.
Not, you don't get any.
218.
Don't fish out.
No, no, no. Where? Please did
That is the dispute interest between them. Is that?
Once let's just page 219 once 219 once at least did. Yes.
Yes.
Whereas the license has applied, licensee has applied to the authority for lease of the plot of land in East Calcutta area development project mentioned and described in the schedule, under written which is in process of requisition by the state of West Bengal for the purpose of the authority under the due process of law. Now, can you consider who have
Unless there is acquisition, how can they even
And this is the statement by the KMDA.
Overzealousness way.
It is a deed executed by KMDA in favor of HON'BLE saying that it is understood under.
Process of requisition, you are also admitting that a board has been.
No, they said acquired, but after award,
acquisition is different. Here they say requisition is not even.
Yes. So according because in view of the subsequent later it will appear that there is no requisition, which has shown to be allotted, which has not been denied. 75, apart from the two is the argument, even if
If that deed has to be taken as a let us see the deed next question.
and that is the defense taken in that sense. That is why I draw your sense in the judgment itself.
Unless requisition process was complete, how could there be the lease deed could be licensed, it could be executed at all.
And all the water supply.
All right. Very.
There is the consequence of because it's Well, 35 to 39. Page. Yeah, page. Right.
Yes.
50. Marvel fund at 38 and 39.
Which page?
Page starts on page 15, my lord.
Page 13 is the last page. There is the paragraph number.
Because
You don't find any paragraph numbers. So, but we have to follow. We have to mark here. We cannot mark.
Online one of their page, that was not.
No, online paragraphs are given.
No, some of the SCC and all India people and bylaw will get right. Some of the
No, they may put in their own paragraphs. This is the original judgment.
yes.
Here no paragraphs are there. Previously, paragraphs sometimes are not given.
38. The efforts of the is established.
Paragraphs.
This I those starts from my lord.
Starts from very. You have opened the starting page.
Yes,
Right.
yes. In the upper section, my lord, you find
Yes, yes.
that though they have pasted or they affixed the notice some other plots, there it was held. Paragraph 38. Thus, we are convinced that in instances the provision of section 3 subsection Land Regulation Act 28 Rule 3 of the Land Regulation have not been complied with. In the other circumstances, the order of revision passed in the land in question cannot be held to be valid for non-compliance with the required provision of section 3(2) of the said Act of 1948 and rules of the said rules of 1948. Therefore, all subsequent steps taken for acquisition of the land in question cannot be held also to be valid. This also said.
No, here categorically held that the order of requisition
Yes.
Cannot be held to be valid.
That's information. So as on this day also they fail to prove whether there is a compliance of section 3. Even if I can assume it is not given to me. So the orders of occupier must be there. Nothing produced because this order, but as on this day by way of supplementary anything that those
So your points, if you could understand you correctly, says right. One is that no prior notice under 3.2, which is your basic point. Second is that even if there was no notice, but there was also a cancellation of acquisition, subsequently page
yes,
80.
yes.
Third point is that there was no valid section 3.1 order also. Two reasons. One is that first page no signature, second page 3 signatures. Second is that step jump into
3-1, 3-3 has been
3.3 also. 3.3 also. And next point is that this regarding dispute of title, 44.2a order is there categorically. You have placed several portions of that order.
and apart from the CS record, it is admittedly our name is
So
there.
that is the next point. We are
Yes.
coming to that. And next is that the position has been taken as per page 102, 103 in terms of the CS records where your predecessor's name was in any event recorded. And lastly, you have cited this judgment of Hondiram versus KMDA, where KMDA has admitted that the title is not clear and the revision is in process. These are all your points.
Well, on the judgments, I would like to come back on some of that. On the points, where I can But first is below the section 3.
Yes. Land acquisition.
Land acquisition.
Yes.
May I first Millard address your Lordship Millard on the step jump Millard as your Lordship?
Mr. Doctor, let us come back and start the hearing because otherwise there will be disruption in the flow.
Now, on the two of Millard,
Step jump.
step jump.
Yes.
It is also a kindly Millard, the purpose of section. But as your Lordship has been pleased to observe that section C, subsection 1 empowers the competent authority to this notice and make further orders. Now, in the section 3(1) notice, your Lordship would find that the further order which has been mentioned over there is to take possession on a particular. That's a handwritten part. Section 3 takes care of a situation if the provisions or the directions in subsection 1 is not compliant. Meaning thereby, take an example that me or the owner of the land was directed to hand over possession, which is the further order.
That is what we are thinking. It would be better if it was said
Yes.
that the owner stroke occupier hand over possession is directed to hand over possession.
Correct.
That would be a bit better suited to the.
Yes. Now, if I do not comply with the direction, then the statute permits the person or the competent
Magistrate or
to take it,
yes.
whoever is under AN.
Okay.
Therefore, my lord, subsection 3 cannot, or without taking possession without under subsection 3 without the alleged non-compliance of subsection 1 in my respected submission is not without keeping over a proceeding.
All right. Yes.
But the next part is which I have already submitted just to for recollection only. But the award has been passed. Money given. Some persons, some may have received.
Money given, was there a record of that? Just give us the pages or first.
So that you are looking to find out the award, though they have denied. No doubt about that. Yes. Please take to the page number 118, where the type copy is at 119.
These are other persons, not their.
Other persons, their predecessor,
What is their predecessor?
I think this is the first page. You should find the number 834, the type portion. What is the problem?
The page 119.
The draft one model bed is type with the
So this is page number.
please.
Oh.
The draft one model you are not find at page.
Rajkumar Mundla at page 123.
That one page.
With Rajkumar Mundla. He is claiming by purchase, the present petitioner.
They claim to be the successors of Prafullo Kumari Dotto.
Yes, but her name is not there.
No, it's
No
not.
Datta is there at all.
But this year also friend. Yes.
Mundol, Chakraborty, Banerjee, Ghoshal.
But Rajkumar Mondol My lord has found what for?
Yes.
Then we have Jivon Mondol and all that, there are few
Yes.
Mondol.
Yes. Yes.
Then Tarungini Dash, wife of so. Then 1/2 MK Ghoshal Road. Then entire land value of 1.17 decimal of Khali land in plot number 3788 E. E means entire. On the right hand side, kindly have a look at the type portion 24,673, then extreme right column paid rupees 24,623 with a check number etc. to Sri R. Chakraborty for Sri Rajkumar Mondal and others with a petition number.
Was this Rajkumar Mondal the receiver whose name was recorded? Was he the receiver? Not sure. 44A is at which page?
44 is acting.
44,
The order.
That is starts from page 157. Here, 157.
At page 170, at the end, it's written, recorded in the name of Ramlal Mondal. Ramlal Mondal's name is there. That Ramlal is also there. We want to see. No, different Mondal. So there's someone. No, someone. They are claiming by succession. So, but
these are all covered. We have taken example where there are various situations. Situation A is award made in the name of a wrong person.
yes.
Apportionment made in favor of wrong persons. Third situation may be wrongful percentage of apportionment. Where instead of 50%, say 20% given to. Now, these are all subject matters which are to be taken to the reference code. But I need all these submissions just for recollection once more. Kindly have a look to section 8 of Act.
Act 2. Yes, reference to.
The collector shall so and so, then we learn subsection 2.
Yes.
The provisions of subsection 2 of section 18 and section 19 to 22 and 25 to 28 of the Act and the principles set out in so far as they may be applicable, apply in respect of reference made to the court under subsection 1. Subsection 1 with subsection 8 1. Now please take note of section 18 of the Act.
Elected.
Any person, subsection 1
yes.
Any person interested who has not accepted the award may by written application to the collector require that matter to be referred to the collector for the determination of the court whether his objection be as to the measurement of the land, the amount of compensation.
Persons to whom is payable. Yes.
Therefore, when the achievement is made in the name of a wrong person, the remedy is by way of reference. Number 1. Number 2, Millard, the section 44(2)A order is several decades after Millard, the award was passed. I think it is in 2005, 4th of April 2005. Whatever. 2005. Because this order cannot invalidate my action of 1976. Number 3, below. But now, number 3 is below the purpose of section 3 subsection 1 is only an intimation that there is a litigation. Nothing new.
Two at least judgments you have to deal with.
Yes,
Because the other
last one has
judgments,
to be there.
Justice Pranab Chattopadhyay's division bench, another judgment has been said that if no natural justice is required to be complied with, the provisions have to be mandatorily complied. But there you may have an argument that that was regarding the modalities of the other modalities, but last division bench you have to deal with
Yes,
clearly on the point.
yes. Because these judgments will not consider the two judgments that I have cited before my lord. One is of Mysore 1961
Yes.
and 2010 will not the Supreme Court major justice.
Yes.
But I've already made this submission.
So you say section 1 is only for the purpose of notice of possession.
Primarily.
And particularly read in the context of the fact that there is no right of opportunity of hearing or given. So the prejudice test also you may argue for. And mere violation of natural justice, if not prejudicial to the rights, does not vitiate the person.
Because natural justice can come into play either by a statutory fiat, legislative fiat,
Yes.
or through the common law.
Yes.
Now, in both cases, today your lordships are of the view that a mere infraction of natural justice itself is not sufficient to vitiate an action. As has rightly fallen from the court, the test is that of a test of prejudice. Someone must come before the court and say that because of non-compliance, I have suffered this. Had there been a compliance, I could have offered this defense and got through.
Even if he was given a notice, he would not have an option but either to leave or be ousted.
Right. That is not the case. And then the other thing is that I don't recollect whether I have cited this decision. Now that Mr. Roy has made this argument, please check your document.
You cited
2009-10
yes, you had.
2009-10 SC6.
You had. Yes.
So please have a look at paragraph 8 onwards. Possibly I have cited
8 to 12 you have cited.
Yes.
We'll just look at that again.
Yes. Who's entitled to a notice?
Yes.
Look, the person whose name is on the records, he is entitled to a notice. The collector or any authority
You are not going to a roving inquiry.
Right. That who else is entitled to a notice.
This goes with your section 44A argument also. So whoever's name was there, I have served, and subsequent post facto cause of action cannot retrospectively be shared. So you have to.
But on the judgment, give me 10 minutes tomorrow.
Tomorrow, very well. Tomorrow we'll keep it as specially fixed so that you can just not. You will take how long? Because you only have to deal with these.
Yes, only to that part of
Very well. Third in part. Oh, sorry, we don't have original sector. We have to wait till next Wednesday. Third in part. So for further hearing, let the matter be listed on January 14, 2026. The partner to achieve. Thank you.
I'm getting and I will take only 5 minutes.
Oh, sorry. You are for the state. No, you are for the KMD.
I am for the state.
Oh, yeah, reverse. Sorry.
And it-
Yes. কি বলছি? হ্যাঁ, ঠিক। দিয়ে দেবে বলছি। প্রথম লাইনে যেটা বললাম তার আগে নোটিস অফ মোশন ফাইল টু রিকেফাইন। নেক্সট।
Equally applied matters, item number 2.
Yes.
An application for restoration of the appeal.
Cemetery is opposite.
I have not argued in that.
No, restoration not within time. Long. How long? Forgot.
1999.
It's like the price tag of a in the supermarket.
Minus 700. 700 because of the COVID period.
No. You know we will not accept that position.
Very well.
Because the order was passed before the COVID. Now we remember. If the order was passed before the COVID period, then you were not.
But
That much we remember. Recollect.
actually the appeal is from an eviction decree with a decree for occupation charges. But by the decree, my lord, there was a special referee who was to assess the mean profit. Probably the plaintiff did not pursue before the special referee, so ultimately the decree was with regard to occupation charges up to the date of the decree. Now, my lord,
Eviction of a tenant.
yes.
Eviction.
Now, my lord, during the pendency of the appeal, we have surrendered possession.
That is admitted.
That is it. The appeal was, but the stay application was filed. There was a conditional stay. That condition was not fulfilled. Thereafter, my lord, we handed over possession. The date is, my lord, 9th of February 2021. Possession is accepted.
Yes.
Well, the first order of conditional stay was passed on 28th of August 2019.
28th
8
August
2019. Delay in filing the appeal was condoned. Cost was imposed for the delay. And
there also your
I was delayed. 670 days when the order starts, your lordship takes the order.
you expel yourself every time. I mean you can't.
But, okay, we can't say anything.
The conditional stay order was passed. After
Conditional stay order was passed, the condition was not fulfilled, there was no stay. And my lord, thereafter, my lord, we filed the paper book also. The extension of time was given, and there was no stay, but we filed the paper book after obtaining extension of time from the appeal court. That is the second order, my lord. That is on 15th of November 2019. Paper book were prepared and filed within the time extended. Thereafter, my lord, nothing, this matter was being looked after by the concerned company secretary, my lord, who resigned. And my lord, since the property was already handed over in 9th February 2021, my lord, the company, my lord, did not have any, did not take any steps. I have to be very candid. No steps were taken because the person, the officer who was looking after the matter, she was not there. This information did not trickle down to the concerned incumbent. The company did not take any further steps, probably because the property has already been handed over. Ultimately, in 2025, well, the erstwhile advocate luckily appeared before the executing court, seeing that the decree holder has filed a proceeding for execution. And there an order was passed for attachment of my bank account. This order,
For the main profit portion.
yes, for the monetary portion. So this order is 1st of July 2025. This he communicated, the erstwhile advocate informed the company that this is an execution matter, has come up in the list, this is an order has passed. Thereafter, my lord, the present company secretary has tried to take out the records and he has
So
ascertained
this is for discretion of the appeal itself.
restoration of the appeal.
When was the appeal dismissed?
Appeal was dismissed for default on February 2020.
February 20th February.
7th February 2020.
What remains in the
No,
appeal, Mr. Sir?
I'll tell you that. Well, now, before the executing court, I have deposited 7 crores. 5 crore was attached.
But there is nothing in your registration application. Sir. You filed this registration application when?
In July 2025.
No, it's on 2nd of August. You
Yes.
might have found it here.
Yes, 2nd of
2nd of August 25 registration.
that is after information of the order passed in the execution proceeding.
But you had appeared in the, it was your appeal, in fact. I mean,
Yes.
so you cannot cite the execution case to say that I was
No,
not.
what I'm citing is the concerned officer who was dealing.
But you
with
cannot
the
do it at your whims and fancies. I mean, concerned officer might have resigned, but the company entity remains the same.
But that is what
There is nothing in this.
But I'll tell you, Archibald,
We'll impose some more costs on you and dismiss it.
but
Because you are not satisfied with the costs previously imposed.
but
5 years later, you come up at your whims and fancy. This is just to avoid the attachment order.
no, but it's not a question of attachment. I have already deposited.
It was your appeal, Mr. Shen.
Yes, but
You had, I mean, there is nothing in your.
But I can have. I have. This is only a thing that I one day your lordship will give us for it. We will. If it is. If I can't succeed, I can't succeed. But the matter.
There is nothing there. If we start allowing these sort of applications, it will give a premium to
But
negligent litigant.
kindly see whether it is actually negligence in that sense.
In what sense is it not? In what sense it is not negligence, Mr. Shen? You file an appeal. That appeal, a conditional order was passed. You don't comply with the order. Just see your conduct.
But
This is not only in the past
but
conduct.
I am not deriving any advantage on the basis of non-compliance of the condition. There is no stay. They did not proceed. They cannot say that my vested rights have been defeated because I kept the appeal pending.
No.
Because they did not also take any steps for my
No,
appeal.
because you intended to hand over possession, you handed over possession. Therefore, you had no impetus to restore the appeal. The moment attachment order is passed, you come back and say that please restore my appeal. So therefore, Mr. Shen, that is your impetus. That is the reason. Because nothing was being done by them, that's why you sat tight and you handed over possession. You lost interest in the property, might have been.
At that point of time, I have said, my financial condition was
But
such
the very fact that when attachment order is passed, you come up with the restoration application itself is a sufficient indicator to defeat the argument advanced by you.
No.
That's what the benefit could have derived. The benefit was there in action. The benefit now you'll derive is to protect the attachment order. Now, when the attachment order is passed, you come up. That is the benefit. You derive benefit by restoration.
But
Not by inaction.
I get it, but the purpose is just to show that after all, your lordships have proceeded on the principle of substantive justice unless
We used to.
it is malafide.
We used to previously. Not in the last few.
But
After the last few months.
But just for my satisfaction, I will just show one.
No, for our satisfaction also, because we have to be strongly satisfied to allow your. You cite the judgments directly, Sir.
Yes, sir.
You have got the dates. You have given the dates.
Yes, 1998, volume 7. 120.
But I am sorry, but it has not been stitched here.
You are separate.
Yes.
Even if it was not stapler, we have a stapler for this purpose. We have to face all sort of situations with
Yes.
the same.
Yes.
So
But I know that.
yes, so this is on.
But this is all only about what is the principle that should weigh in the mind of the court for the purpose of exercising discretion. Whether it is the length of the delay.
Settled. Yes. I'll give the paragraph.
But kindly see paragraph 9 once more.
9. Axiomatic.
Yes. And here it is a case of 883 days.
Yes.
It is axiomatic that provision of delay is a matter of discretion of the court. Section 5 the Limitation Act does not say that such discretion can be exercised only if the delay is within a certain limit. Length of delay is no matter, acceptability of the explanation is the only criteria.
But in the latest judgments, Mr. Shen, this has been distinguished, deviated from. It has been, there are certain judgments. 2 of the judgments must be cited by them. We hope they will cite that one is that length of, if it's not of prolonged, I mean the length is not much, then it can be considered. And merits also will not be considered. Anyway, we are taking this.
And this paragraph also, kindly see,
Yes.
13. It must be remembered that in every case of delay, there can be some lapse on the part of the litigant concerned. That alone is not enough to turn down his clear.
Malafides has to be shown.
Yes, malafides.
Right.
But I am not.
This was the established principle.
Yes, but here when it is a case, I am not
Deriving benefit.
no, not even benefit. What is my malafide action? I have acted. I have given in the possession. It is not a case that I have held on to the possession aspect also. And I am saying what company is a body of persons acting together, where one employee was in charge of the matter. It is not in the business of company administration. It is not that the others will have to be equally responsible
Mr.
as that person.
Do you seriously think any company worth the name of company, the name of a company, will not have a handover of the charge when a person resigns?
That I am not saying that.
What will you do if your clerk leaves profession today? What will you do, or what will you do?
That is my personal interest. I will have to.
If you are a company, if not even the directors, all the directors left the company could understand. Some new directors have come in. Even then, they will be more cautious. Maybe. One company secretary leaves the company. Very well. Obviously, she will hand over her charge to the new person, new incumbent. If she does not, then you will take care. You will
But
direct.
then the present incumbent at the most is guilty of some which has to be borne by the
Present incumbent is your representative.
Yes, my representative.
So you are the principal.
I become responsible for the acts of the agent.
Yes.
I become liable for the acts of the agent.
Absolutely, Mr.
But so in this type of cases, I have also secured his entire claim. It is entire claim in the sense I say whatever he has said, the principal amount, that is secured.
That was by court's order.
Of course, not by court's order.
Court's order annual also.
Today, my lordship will see when the appeal court granted the condition. If the appeal was alive as on today, I would have had to pay that till the date of delivery of the possession. And
but you delivered possession not of your own volition, because you, in any event, you had failed to meet the condition of stay. So in any event, you were under jeopardy.
No, but even if I had not, if I had not,
they would have ousted you by evicting.
They did not. That is what I am saying. I did not deliver possession.
That is their goodness, not your goodness.
Being forced, not being forced by an order of court. I have delivered possession for whatever reason. But kindly allow me to contest the claim of damages. This is a claim for damages, and that of also, my lord, kindly consider one aspect. It is a case of interest on damages. It is like occupation charges or mean profit. This is another form of damages. It's a principle of restitution. This is a claim which arises on account of I have given it, but I am still ready, but whatever is the 5 crores which they had asked for, principal amount, I am not in dispute. The learned judge has awarded interest from that previous and anterior date. So, my lord, your lordship will only consider that aspect of the matter in a case of award of damages. Interest on damages from a prior date. That is what, my lord, I am suffering. Nothing else. Well, that is the only issue which your lordship will be concerned with in this limited appeal.
There is gross negligence on your part. Mr. Gross negligence.
But gross negligence, your lordship is calculated, your lordship. I can be forced to compensate them. But my substantive right will go. Well, and this may be a matter of
You
one.
are just coming up at your whims. You are a company. You are not in. You are never in liquidation. There was no CIRP. You
No,
have existed all along as a company, as a juristic entity. You knew there was an appeal because it was your appeal. You filed the appeal with a delay, whatever delay. Section 5 allowed. Then the condition was imposed, stay granted, failed that condition. And only after it was that stay was automatically vacated due to your non-compliance, after that you handed over possession. Not like a good Samaritan. You, after it was vacated, you had handed over. And now, when do you file the recall application? You were all along aware of your appeal. The company was aware of its appeal. It waited for 25 years and when 5 years. And when do you file this registration? The instigator was this
the order of
attachment.
Order of attachment.
So it clearly shows your malafide, Mr. Shen. If the order of attachment was not passed, you'd never file a registration application. You'd sit tight forever.
I am only
and wait for when if the attachment order was passed 10 years later, you'd file this application after that.
I would be only
Delay, you are right. Delay is not a necessary factor. But your conduct.
But to the extent of malafide or conduct, kindly see whether that your lordship will balance, whether it can be adequately compensated also. I am not saying
the balance is very tilted on one side, Mr. Shen. You don't have anything to put on your side of the balance.
But I put in the entire security, but he is
by order of court, security and principal.
He is not without security.
The decree by word, the execution application is for 25 crores. The court said you deposit or attachment for 5 crores. And on the first day, when the execution application was, the claim is for 25 crores as per the decree.
But that is the question, that is with interest.
So
I
I already said that the entire claim has been.
I am only on the question, he is secured insofar as his main sum is concerned, which does not require adjudication. But the other part of the
5 crore was the principal.
Yes, 5 crores. Maybe a little less also.
Maybe a little less. Because
Little less.
1/5 was that. 25 crore was it.
But we have offered, we have given.
You can cite your other judge. This is the judge.
This is the judge. I only beseeching your lordship, but this is a case where your lordship can compensate them for this action and not take away my substantive right, just to present my case. It's a matter of 1 day for your lordship.
No.
Only 1 day, my lord.
Not a question of us. It's them.
1 day in the sense, the appeal is a very short point.
No. That is not a consideration at all. How much time the court will take to.
No, that is not. I'm saying to the extent whether further prejudice will be caused to them by condonation of the delay. That your lordship will also see because whether what is the impugned order to the what extent I have a right to challenge that. It's a very short issue,
Will you let Mr. Mitra justify his presence? Only that. And you can cite the latest judgments 1 or 2, Justice Pardiola, Justice Bela. If you have not brought, then don't cite. We'll decide this.
I will justify my presence by saying, that my learned friend said the question of malafide.
Yes.
The question of malafide, lordship will kindly take up the petition. What is their case? That the concerned company secretary, left the services in September 2020. If your lordships are pleased to come to paragraph 13 of the application. The aforesaid matter was during the relevant time being entirely handled by so and so, the then company secretary of the appellant who left the services of the company in or about September 2020.
Oh,
It was
February it was dismissed.
February, numbered one. Then, my lord, kind few more paragraphs, my lord, to justify my presence. Paragraph 50.
Yes.
Again, they say, my lord, last 4 lines. Moreover, as the matter was also being handled by the erstwhile company secretary who had left the services on September 2020, the new incumbent, I do not know who, not named, a new company secretary has not affirmed this petition. The new incumbent had no occasion to inquire and or ascertain the status of the appeal. Then, my lord, kindly come to the next page, paragraph 70.
Yes.
It was at that stage that the present company secretary started making inquiry with regard to the proceedings in respect whether the execution case had been initiated by the respondent. After making thorough inquiry and after communicating with the erstwhile learned advocate, he could ascertain himself of all the earlier orders passed in the appeal as already referred to in the preceding paragraph. It was thereafter he took assistance of another advocate for ascertaining the current status of the appeal. The said learned advocate thereafter brought to the notice of the present company secretary about the order dated 24th January 2020 and 7th February 2020. From the said orders, the company secretary entrusted to look into the matter could ascertain that the matter has been dismissed for default on 7th February 2020. As none appeared for the appellant dependent company, the said company secretary could also gather information that a notice communicating the order dated 24th January 2020 was apparently served upon the appellant.
What was that order that it would be dismissed for under?
24th was they did not appear, so give notice. I gave notice. They do not deny that they that, my lord, they received the notice. The order is at page, my lord, kindly come to page 21 and 20. Kindly come to page 21. Second paragraph, the respondent will inform the appellant that the matter will appear a fortnight hence and may be dismissed if the appellant is not represented on such action.
So advocate for the appellant said that the appellant has revoked the authority of the said advocate.
Nothing on record. Nothing on record. In any event, assuming that is correct, I gave notice. Then, my lord, on 7th of February, it was dismissed. Now, this is not the point of my appeal. My lord, kindly come to my affidavit in opposition. Once, my lord. My lord, kindly come to my affidavit in opposition, paragraph 5. Page 4.
Yes. Paragraph 5.
Yes. Sonali Choube, company secretary, has resigned. Paragraph 1. Has resigned from the appellant company on or about 7th December 2021.
Not September.
Not September 2020. Their allegation is September 2020.
Yes.
She resigned on 7th December 2021. The appellant has deliberately misrepresented and had made false statement on oath that the said Sonali Choube had left the services of the company in or about September 2020. Further, Sonali Choube, as the company secretary of the appellant, had signed the 29th annual report of the appellant company for the year 2020-2021 and had also filed a half-yearly reconciliation of shares and capital audit report before the Register of Companies on behalf of the company for that period. In this regard, 29th and 30th annual reports of the company are annexed. Now, kindly come to page 11. This is why I say, my lord, Malad. My lord, kindly come to page 11. Sorry, 11. 12. Yes, 11. 29th annual report. Kindly turn the page, my lord. Annual report is filed after, my lord, 31st of March 2021, kindly come to page 12, right hand side top, company secretary. Then kindly come to the bottom one, just above factory, on the right hand side. Solicitors. Same way. Then, my lord, kindly come to page 19. Kindly come to page 19, my lord. Notice of 29th annual general meeting. Notice is, sorry,
Yes.
on the left hand side. Notice is hereby given that the 29th annual general meeting of the members of ARCL will be held on 30th July 2021 at 11:30 a.m. Kindly come to page 22. Who is issuing this notice? Sonali Chobe as company. And my lord, date is 8 June 2021, the issuance of notice. Now, my lord, kindly come to page 92. Lordship should be pleased to come to page 92. Yes, page 92 is the next annual report. Kindly come to my lord towards the bottom on the right hand side. Solicitor. The company secretary has definitely changed. But definitely, my lord, after my lord, June 2021, not in September 2020. Yes. Kindly come to page 162. Now kindly come to page 162 at the top.
Designation date is given.
Yes. 7th December 2020. And there specific case at least on in two places that she resigned in September 20. Now, well, this is the matter. Kindly come to one more document, my lord, page 172.
Yes. 8 June.
8 June 2021. Last but one paragraph.
Yes.
Resolve that Sonali Chobe, company secretary, beings and hereby authorized to do such and such.
Yes. Yes.
Now on malafide, my lord, there are judgments, my lord. I can 2010 volume 8 Supreme Court cases 685. The facts would appear, my lord, from paragraphs 3, 4. Kindly come to paragraph 9. It is clear from a bare reading of the above paragraph that the applicants were totally careless about pursuing their appeal. They have acted irresponsibly and even with negligence. Besides this, they have not approached the court with clean hands. The applicant who seeks aid of the court for exercising its discretionary power for condoning the delay is expected to state correct facts and not to state lies before the court. Approaching the court with unclean hand itself is a ground for rejection of such a. Well, that is the paragraph, well, then this is, well, the consistent view. In fact, I found, my lord, an old division bench judgment of this honorable court, my lord, reported in 98 CWS says the same. Before going into, my lord, the 98 CWS, my lord, may I show, my lord, 2013 volume 14 Supreme Court cases, page 81. Kindly come to paragraph 11. The expression sufficient cause should be given a liberal interpretation to ensure that substantial justice is done, but only so long as negligence, inaction, or lack of bona fide cannot be imputed to the party concerned. Whether or not sufficient cause has been furnished can be decided on the facts. Next, it is a settled legal proposition that the law of limitation may harshly affect a particular party, but it has to be applied with all its rigors when the statute so prescribes. The court has no power to extend the period of limitation on equitable grounds. The result flowing from a statutory provision is never an evil. Court has no power to ignore it, etc. Kindly come to paragraph 15. The law in the issue on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause which been set, adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case, or found to have not acted diligently or remained inactive, there cannot be a justified ground to condone. No court could be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided. Now, my lord, I am not, my lord, citing, my lord. I find, my lord, that a recent Supreme Court says that in case of delay, you have also to explain the first period, the 30 days.
Yes.
Why you did not act within that.
Please don't.
No. I'm not formally citing 98 CW, my lord, 298. It says
These covered. These judgments
Says
covered.
the same.
In only paragraph 6 of my reply, my lord, I have said that this is an inadvertent error.
This is an inadvertent error.
But this date,
Shonali Joe.
the date of resignation, which I have mentioned in the petition, kindly see paragraph 6 at page 4. And I have said, my lord, this is an inadvertent error, and I have prayed for apology, my lord, for me. I am only saying this, my lord, by putting in that date, I did not want to get any advantage. Question is, it was dismissed for default during the tenure of that person. Whether it is September or the actual date, which is December 21. My case is that she did not take the steps which was required to be done on her part.
Let us come to that relevant paragraph.
Yes.
Paragraph 30. Okay,
13 and 15.
13.
The premise of para 13 is that she had left.
She had left, but when did she leave? She left on December.
You have not attributed any negligence to her here.
But
You don't say that she was negligent.
No, but I have said later. Your Lordship, kindly see.
Where have you said that? The impression which you seek to give in para 13, Mr. Shen, is that because she was handling, she left, therefore you are left in the lurch.
My lord, 17, the lawyer also changed.
Para
That
18,
is also incorrect.
para 18, your Lordship will just see facts and circumstances show that the erstwhile company is looking after and handling the criminal, particularly in January, had not taken steps to represent the matters, particularly after there was some communication gap with the erstwhile advocate and whose authority.
You have said erstwhile advocate, your advocates even the same in your audit report. Set of advocates even the same, and his name is one of the names is also appearing in one of the orders.
No, in this appeal, we have
In this appeal, the name appearing in the audit report, one of the names, if you see this order,
Yes. Same.
we have checked up.
The second name in the audit.
Second name in the audit report is the first name in the order dated January 24. We don't know whether that he's appearing. He's also appearing now.
no. He the order, but his submission is recorded that his authority has been revoked.
Oh yes.
He himself has submitted that. And but he luckily, my lord, he appeared before the executing court and informed us. That is also a matter of fact which we have said.
After this, after it was revoked, and his name was consistently shown in an audit report even after this to be there.
Yeah, that is not, my lord.
So the advocate conduct was also malafide. His name was he appeared for you after his authority was revoked, and he was continuous.
Execution was served on the company and he appeared. Thereafter.
Sir,
Well, execution was levied after 2 years. Your very explanation, Mr. Shen, says that he appeared on behalf of the company.
no, that is I have said.
Then
that
this-
he has informed us about the order.
Then
Then
this
only
advocate appearing for the says that he's revoked, his authority is revoked, is not correct. And you have not explained this in your erstwhile advocate story. You have said that communicating with the erstwhile learned advocate,
No, but we have said that his authority has been revoked.
he was apparently found to be worthwhile, not erstwhile. He was retained.
No, he was not.
He was retained till the execution case was
No,
levied.
execution case, he appeared.
He did everything good for you.
It is my instruction is that there was no wakalat.
But this
In the
advocate,
execution.
despite not there being no vakalatnama, he appeared for you. In the execution case, he knew about the attachment
Kind
of
of like the order in the execution.
Attachment.
Yes. He had just appeared on the matter.
Why should he appear if his power is revoked? And why is his name appearing in your annual report?
I really want to know.
Mr. Shen, you must take note of this, that in your annual audit report, generally names of firms are given. We understand that. But specifically, this learned advocate was named along with the firm. Not only the name of the firm, the advocate's firm, the law firm, but the advocate's name specifically, repeatedly after in 2021-22. That is what we noticed from that order. So this application itself is a malafide.
Page 19 of the restoration application was ordered in execution. It's not that matter. It was after 2 years. Company was served, he appealed. Page 19 of the restoration.
Yes, because that is their stand also that he appeared. They are not denying that he appeared. But his name is recorded, I mean, he appeared full-fledged. Mr. Shen, it's not that he was wandering by and suddenly a bird flew by and dropped a message that your matter is going on in which you are no longer there. Mr. Shen, don't do this to yourself. Please take it. The present application for restoration on condonation of delay has been filed on August 2, 2025, whereas the appeal was dismissed for default on
Was 7th February 2020.
thank you, on February 7, 2020. So next para. Learned senior counsel appealing for the appellant places reliance on the amendments made in the restoration application to submit that there were no malafides on the part of the appellant company at any point of time, thereby justifying a lenient approach to be taken by this court in condoning the delay in filing the application. So next para. It is contended that one Ms. Sonali Choube, the then company secretary of the appellant company, who was handling the litigation on behalf of the company, had left the services of the company. Full stop. Next para. It is pointed out that although in the restoration application it was mentioned that the said company secretary had left the company in or about September 2020, after the said after the incorrectness of the said statement was pointed out in the affidavit in opposition by the respondents, in the affidavit in reply, apology has been sought, admitting that the said date was erroneously mentioned, whereas the company secretary had left long after in the month of December 2021. Be that as it may, it is submitted by learned senior counsel that during the regime of the said company secretary, the appeal got dismissed for default. Only much subsequently, after the erstwhile learned advocate for the appellant intimated the appellant company that the appeal had been dismissed for default and the impugned decree had been put into execution, and in connection with that, an attachment order was passed by the executing court, did the appellant learned about such dismissal for default and immediately engaged a new advocate who, upon taking information, came to know about such dismissal and the surrounding circumstances. So, next paragraph, senior counsel appearing for the appellant cites such and such number party reported at 1998 7 SCC 123 in support of the proposition that the length of delay is immaterial in condonation of delay, whereas the acceptability of the explanation is the only criterion. To next para, it is further submitted that the Honorable Supreme Court held in the said report that if the explanation given for the delay does not smack of malafidis, or it is not put forth as part of a dilatory strategy, the court must show utmost consideration to the suitor. Next para. Learned senior counsel submits that no advantage could have been derived by the appellant from the delay occasioned in preferring the instant application for restoration, since in the meantime, the possession of the decreed property has been handed over by the appellant in favor of the decree holder stroke respondents on or about February 9, 2021. Next para, it is candidly submitted by learned senior counsel for the appellant that the appellant had failed to comply with the condition imposed for grant of stay video order dated August 28, 2019 by non-payment of the occupation charges. However, it is insinuated that such non-compliance was due to the loss of business and stringent financial conditions at the relevant point of time undergone by the appellant company. Next para, learned senior counsel appealing for the appellant places reliance on the annexures to the application for restoration to indicate that the knowledge was derived regarding dismissal of the appeal for default only on July 1, 2025, soon whereafter the present application has been filed. Full stop. Next para, learned senior counsel appearing for the respondent opposes the prayer for restoration and condonation of delay in making the uh, said application. Full stop. Next para, learned senior counsel places reliance on the judgment of such and such reported at 2010-8 SCC 685, wherein the Honorable Supreme Court, inter alia, had observed that the explained delay should be clearly understood in contradistinction to inordinate unexplained delay. To stop delay, it was held, is just one of the ingredients which has to be considered by the court. So in addition to this, the court must also take into account the conduct of the parties, bona fide reasons for condonation of delay, and whether such delay could easily be avoided by the applicant acting with normal care and caution. Full stop. The statutory provisions, it was observed, mandate that applications for condonation of delay and applications belatedly filed beyond the prescribed period of limitation for bringing legal representatives on record within bracket in that case bracket closed should be rejected unless sufficient cause is shown for condonation of delay. So next para, learned senior counsel appearing for the respondent further cites OMO reported at 2013-14 SCC 88, where the Honorable Supreme Court had observed, inter alia, that it is a settled legal proposition that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribes. Full stop. The court has no power to extend, it was held, the period of limitation on equitable grounds. Full stop. A result flowing from a statutory provision is never an evil, the Honorable Supreme Court went on to observe, and the court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. Full stop. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. Full stop. Next para. The Honorable Supreme Court, in the said judgment, deprecated equitable considerations in condonation of delay. Full stop. Next para. Learned senior counsel for the respondent then takes the court to the annexures to the affidavit in opposition, wherefrom it is evident that in annual audit reports filed by the appellant company, much subsequent to the dismissal for default, the said company secretary named in the restoration application has been consistently shown to continue in such capacity vis-a-vis the appellant company. Full stop. Only on December 7, 2021 was the said company secretary, namely Sonali Choube, shown to have resigned from the company in one of the annual reports. Full stop. Next para. Thus, it is argued that the very premise of the restoration application, being that the appellant was in a difficult position vis-a-vis the litigation due to the erstwhile company secretary having demitted office, is vitiated by malafides. Full stop. Next para. That apart, learned senior counsel for the respondent points out that it will be evident from the order sheet of the execution case that the so-called double-inverted erstwhile double-inverted clause advocate of the respondent had consistently appeared even in connection with the execution case, obviously on instruction of the appellant company, comma, since notice of execution was served on the appellant company itself, full stop, without the specific instruction of the appellant company, comma, the said learned advocate, comma, it is submitted, comma, could not have appeared. Full stop, even otherwise, comma, the same learned advocate, the same learned advocate, comma, whose name appears as one of the counsel appearing on behalf of the appellant company all throughout, comma, was also indicated in the annual audit reports of the company as one of the counsel for the company, appellant company. Full stop. Next para, thus, comma, the reliance of the appellant company in its restoration application on the allegation that it had changed its advocate, comma, which might have created a confusion as to knowledge about the dismissal for default, comma, is also based on falsehood. Full stop. Next para, learned senior counsel takes the court through the pleadings in the affidavit in opposition and submits that the very basis of the restoration application being malafidis, comma, the same ought to be dismissed. Full stop. It is also pointed out in the passing, comma, in reply to the contention of the appellant that the appellant had secured the decretal amount, comma, that the deposited amount was only to the tune of rupees 5 crore, whereas the decretal amount is about rupees 25 crore. Full stop. Next para. Upon having carefully considered the arguments of the parties, comma, we find patent malafidis in the making of the restoration application. Full stop. Contrary to the arguments of the appellant, comma, we find that the very basis of the pleadings made in the restoration application are an attempt to mislead the court. Full stop. First, comma, in paragraph number 13 of the application, comma, it has been stated that the aforesaid matter, within bracket the appeal, bracket closed, was, comma, at the relevant time, comma, being entirely handled by Ms. Sonali Choube, the then company secretary of the appellant, who left the services of the company in or about September 2020. Full stop. Next para. It has been repeated in paragraph 15 of the application that as the matter was also being handled by the said erstwhile company secretary who had left services on September 2020, comma, the new incumbent had no occasion to inquire and stroke or ascertain the status of the appeal. Full stop. Next para. However, comma, since we find from the records that the said erstwhile company secretary resigned much later, only on December 7, 2021, comma, the period between period between the dismissal for default of the appeal on February 7, 2020 and December 7, 2021 is remains unexplained, even as per the averments made in the restoration application. Full stop. Also, next para. Also, comma, on the allegation made in the restoration application that the erstwhile learned advocate had been changed in the meantime, comma, we find the same not to be correct, comma, since the name of the learned advocate who had appeared all along appears consistently in the execution case as well. Full stop. Next para. It is not quite credible that a learned advocate whose services were dispensed with in the year 2020 would, comma, of himself, comma, be charitable enough to appear of his own for the appellant company without any specific instruction in that regard from the appellant. Full stop. Next para. Thus, comma, the very premise of the date of the subsequent date of knowledge of dismissal of the appeal, that is from the execution case when such advocate came to know of the same and informed the company, comma, is also vitiated. Full stop. Next para. That apart, comma, we do not find any trace of bona fides and diligence in the conduct of the appellant. Full stop. Although past conduct may not be very relevant, comma, the same cannot be totally overlooked to assess the present conduct of the appellant as well. Full stop. The appeal itself was filed after a prolonged delay, and the delay and such delay was condoned, and an order of stay was passed in favor of the appellant at the outset, imposing occupation charges as condition for such stay on August 28, 2019. Full stop. The appellant failed to comply with such direction. Full stop. Hence, the handing over of possession by the appellant to the respondent on February 9, 2021 was not an altruistic act on the part of the appellant, but under compulsion, since the stay order had automatically stood vacated by virtue of non-payment of occupation charges, which was a condition for stay. To sub next para, that apart, the argument of the appellant that no advantage could be derived by the appellant by the delay cannot also be accepted. Full stop. It is only when the attachment order was passed on July 1, 2025, that on the threat of such attachment, the present restoration application has been taken up. Full stop. Next para. We do not find any plausible explanation throughout the pleadings of the appellant in the restoration application or in the connected affidavit in reply as to why the appellant, which is an independent juristic entity, did not take any steps throughout the period of 5 years for restoring the appeal. Full stop. Next para. It is well known that when a particular functionary of a company demits office, he uh, uh, apprises the current incumbent, the subsequent incumbent, of the tasks left unfinished by her. Full stop. Hence, we do not find any uh, plausibility in the averment in the restoration application that merely due to the previous company secretary, who was in charge of the litigation, demitting office, the new company secretary was not in the know of the appeal preferred by the company itself. Push up. Next para. Thus, the proposition laid down in N. Balakrishnan Supra is not applicable in view of the malafide conduct on the part of the respondent, on the part of the appellant, petitioner. Full stop. Moreover, in view of the ratio laid down in Prem Singh Supra and Balwant Singh within dead close Supra, we do not have any hesitation to hold that the appellant, being guilty of malafides and being grossly negligent at all stages, is not entitled to the equitable relief of condonation of the delay in filing the present application. Full stop. Accordingly, this is GA 70 session. Oh, sorry, GA 6. Accordingly, GA 6 of 2025 is dismissed on contest without any orders to cost, thereby, without any orders to cost, no further order. This.
Only one possible event.
Yeah.
2013-14 Supreme Court cases, page 81 possibly has gone down as page 80.
Oh, achha. 13-14, page 88. You have cited page 80. Page 80 is the actual page. 11-12 of this judgment.
13-14.
Achha.
81.
Oh, achha, no.
Oh.
81. 2013-14 is system 81. Yeah. Not now.
My lord is taking up
Appellate, sir.
madam,
Can't be-
but 21, my lord, some president. But my second is from all of you. Any day, my lord, Friday, my lord.
You're not responsible for that. Coming to you later. Don't ask her not to come to me.
My lord, it's very short. my lord.
Not now.
Any other sir?
Yes.
Sitting with pilot just.
See, hand over whenever you sit, please. Yeah. Correction.
For collection only to the list of names of animals. To be made. So 841 fully application. Order for the rule.
Okay.
First time hearing.
Yes.
Item number 1.
My lord, would be my lord's kind pleasure, my lord, to take it up on any other day. I'm really bad today. We have the money ready as per your lordship's order. There is no difficulty at all on that, my lord. Just for the hearing, my lord, just give me one day today in real difficulty.
We'll adjourn for the day then, Mr. Chair.
Yes, my lord. Whenever your lordship pleases.
I think the order, last order records them.
Yes.
It was specific, it records everything. Suit for specific performance. I am the
Is
landowner.
that readiness and
Yes. I am ready to sign the documents, whatever comes.
so he says
My lord,
that
yes, just give me one day's time. You know,
yes,
there's a
yes,
problem
we'll do that.
with respect to the amount. I will adjust that before your lordship, and yes, of course, whatever is required can be done.
On the period of learned senior counsel appearing for the appearance, the matter is adjourned for the day and shall be listed tomorrow under the same heading. Same heading should appear there.
The order we handed over to us tomorrow.
Tomorrow we'll make a comprehensive order.
Great for the lordship.
Item number 2.
When does it expire, Mr. Chatterjee? You're oh, he's very yes. Mr. Chatterjee, when does the interim order expire? Expires.
On 9.
You're extending. Have you given a notice to the other side?
Yes, no. Evidently something exchange for the.
No, for this because it is appearing under the heading extension.
It was yesterday, or day before yesterday, he appeared.
I was not.
No, you are not present. But the other side appeared.
Yes, already they entered that year.
Good. The interim order granted earlier is extended till February 28 to 26 or until further order, whichever is earlier. The application is still pending.
Still pending.
The application shall be listed for hearing on January 13, 2026. Next, please.
G to 15.
3 to 15. Yes. That's the board. Yes. All the matters same explanation from the same procedure.
The proceeding for a death seller knows that the order passed by the learned. Is that reference? Reference to reference or this is
Different persons, so therefore different reference. Yes.
And
1060.
But it is the when the COVID was
What was it?
that
COVID.
500 something days yes, but
No,
it
the
is
judgment
written-
was passed during the COVID period.
no judgment was passed.
Then you cannot get admitted. That is only applicable to judgments which are
See the report of the stand. Because it was filed within the COVID.
no filing within the COVID period. If the judgment was passed within the COVID period, Mr. Shanmugam, you
No.
can that.
But I the
Wrong. We will ignore this.
Long.
It's an absolutely wrong.
Before wait is anything is done.
but
When was the judgment? Was the judgment?
judgment was December 2018.
Then wrong report. We'll ignore the report and but you have given explanation for the entire thing. What is the explanation you have?
Explanation matter is there. Probably if they object matter, then matter I have brought the judgment matter all those judgments and
What judgment?
that my lord has dealt with this latest 2025 judgment that is Supreme Court and Justice Dhiren Johnson proposed.
Yes, Mr. Kajiwardis.
My lord, government, their own explanation and how I shall, whether.
How do you know whether the explanation?
How I shall use their, my lord, subject to approval of your lordship, my lord. Most of the matter your lordship passed order No payment is deposited in most of the cases.
Then the stay order gets vacated. You execute it.
You know, that my lord's order was contrary. No, that is my lord has issued an order, passed an order directing the concerned of the district magistrate that to pay the technical amount which was deposited.
That is
But here it is not because it has not been heard.
my experience, my lord, well, because
No, we'll direct for grant of stay. We'll direct them to deposit the entire amount.
and either the amount is being deposited and execution court is also alert.
No, no,
No,
not
if any such case comes up, Mr. Mukherjee, you can make an application. We'll vacate the order.
Take it automatically. Your order.
Yes.
Subject.
Then you execute the order.
What your
Then Mr. Mukherjee, you execute the award. You have a revenue.
that is why this is most of the cases. Either if they did not,
so far I have
If they did not deposit, it's not being executed. It take to 27.
and that is why, madam, even we had to move for the revisional court in
Yes,
between. Madam, one
That-
thing, if your lordship, madam, subject to approval by your lordship.
Yes.
Madam, kindly allow us to prepare the paperwork at our places.
But I am not.
Please, madam,
They'll be very happy.
That will be better.
Otherwise, that will also take another year.
on the last occasion, they did not allow us. Whether you remember.
No, that another matter.
After all,
I
carrying up to
Anyway, let us forget the previous matter. All these matters same experience.
Yes.
একটা
analogous,
common order হবে। All the present appeals arise out of the self-same land acquisition proceeding, comma having been preferred against award passed on reference in favor of the respective respondents. To the next para, learned counsel, learned
Well, we said remove this special messenger cost to bring all these.
yes, learned senior government advocate appearing for the state submits that due to interdepartmental delays, comma beyond the control of the appellant, comma the appeal has been filed belatedly. To sub next para, such contentions are controverted by learned counsel for the respondent in each of the matters. To sub, however, comma on a careful perusal of the explanation furnished in the application, we find such explanation to be plausible. To sub accordingly, can 1 of 2021 in each of the above appeals is allowed, comma thereby condoning the delay in preferring the said appeals. To sub the appeals be deemed to stand registered and admitted accordingly. To sub there will be no orders to cost. To sub can 2 of 2021
at least 3 months, well, kindly, because again.
yes otherwise you will not get the one.
No,
Can 2 of 2021
Payment position as of the generations are going on.
what the
My photo is
Can 2 of 2021 is an application for stay filed in connection with each of the appeals, comma seeking stay of operation of the impugned decrees. Full stop. Impugned awards. Full stop. Next para. Since questions of both facts and law are involved, comma the appeal is required to be heard on merits. Full stop. Accordingly, can 2 of 2021 in each of the appeals is disposed of by granting stay of operation of the respective impugned awards in each of the appeals till disposal of the said appeals, comma subject to the decretal amount being subject to the awarded amount being deposited with the Registrar General of this court by the appellant within 3 months from date. Full stop. The stay order shall continue unconditionally for a period of 3 months. Full stop. And in the event such deposit
at least
is paid within such period, comma the stay shall continue till the disposal of the appeals. Full stop. However, comma in case of default of such payment, comma the stay order shall automatically be vacated, stand vacated without further reference of the court, and it will be open to the respective respondents to put the impugned awards into execution. Full stop. Next para. On the prayer of learned counsel, you will also put in the special messenger clause there.
Yes.
On the prayer of learned counsel appearing for the respondent in each of the matters, comma the trial court records are directed to be called for by special messenger at the cost of the respondent, comma deposited within a fortnight, deposited within a week from date. Full stop. Next para. On similar prayer, comma the respondent in each of the matters is directed to file the requisite number, prepare and file the requisite number of paperbooks in the appeals within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the respondent. For such purpose, notice of arrival of the trial court records shall be served on the learned advocates both for the appellant as well as the respondent. In view of the appearance of the respondents in each of the matters to their learned advocate, service of notice of the appeals on the respondents is dispensed with, and the appeals be treated to be ready as regards charges. Liberty to the appeals shall be heard analogously. Liberty is given to the parties to mention the appeals for inclusion in the list whenever the appeals are made ready for hearing.
And allow us to withdraw 50%.
Mr. Then we'll have to furnish some security.
Security or bond, your lordship partial order, bond of the security.
Again, if you lose the case, then you'll have to return that. What is the use of
bond?
You have already got the admitted.
That is the enhanced amount. Your lordship 67 position we have lost. And when it will be at the value of the amount, so much
security, then will
the amount
the security will be to the satisfaction of the registrar general.
This security oblique bond.
It is made clear that the respondents in each of the appeals will be at liberty to withdraw 50% of the deposited amount upon furnishing of security stroke bond to the satisfaction of the learned registrar general. Next para, such withdrawals shall be subject to the outcome of the appeals. Next para, as and when such deposit is made by the appellant, after payment of 50% of the amount to the respondent on furnishing of security stroke bond as directed above, the balance amount shall be deposited in some short-term interest-bearing accounts to deposits with any nationalized bank by the learned registrar general. ওটা হচ্ছে স্টে ক্যান টুটা আচ্ছা এটা তো ক্যান টু অফ যেটা বললাম ক্যান টু অফ 2021 আর প্রথমটাতে ক্যান টু আছে স্টে প্রথমটা ক্যান টু
Maybe, my lord, at the time when that COVID period was going on, that application has to be filed. I mean that
ও আচ্ছা 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 যেটা বললাম ক্যান টু অফ ইংলিশ অফ দ্য ক্যান টু অফ 2021 ইন প্রথম অ্যাপ্লিকেশন নাম্বারটা হচ্ছে in FAT 131 of 2021 and CAN 3 of 2021 in all the other appeals. তারপর যেটা বলেছি হ্যাঁ অ্যালাউড হয়েছে আর আরেকটা অর্ডার পুরোটা হয়ে যাওয়ার পর লাস্টে একটা করে যে CAN 2 of 2021 in এপিটি নাম্বার এটাকে নাম্বারগুলো দিতে হবে 4 থেকে 15 থ্রিটা বাদ in FAT number such and such are also allowed, thereby dispensing with the filing of certified copies of the improved hour in the said appeals.
Well, now the matter is over, my lord. On the last occasion, I lost that. But however, my lord, I got the recent judgment. My lord, time is on.
When we take up the matter, just keep it with you, sir, because you will be reading this judgment. This is on what?
This is for, my lord, because is the coordinate bench.
On what point?
What point is the coordinate bench, my lord, delivered a judgment on the some issues. And my lord, the same coordinate bench, yeah, this is it's an absolute settled principle of law. But my lord, this is reported in, my lord, just my lord, Supreme Court, but not reported.
What is the proposition? The coordinate bench.
Contents is that the coordinate bench has to accept that. Either if there is, well, then the settled principle of law, if they differ, then that will matter. No, because I didn't get the recent judgment. That's why, my lord, I'm sorry. Because other, but it is the latest reportable judgment that is reportable January 5th, 2020. I will.
Whenever an official comes to cite it,
Because there are cases where I will.
no, definitely. You keep yourself abreast, Mr. Sharif, very well. Yes.
Item number 16.
Six. Yes. Some of the
The respondent number 180, but when hearing the respondent, whatever file has not been deleted, when he died manner and the however.
This manner,
we directed his name to be deleted.
Yes, madam.
That we have already passed directions.
My lord, yes, madam, that was allowed.
Is that now?
Yes, my lord.
Altanu and Shantanu is not there in the hospital. The
What about
normal
that?
is Shantanu.
Well, they should be incorporated in this application.
So you have to file an application for that because it's already
Madam,
time
that
out.
application has been filed, that was allowed, madam, but the present application which has been filed subsequently, madam, in that application, madam, that the previous name.
In the memorandum, it has been corrected.
In memorandum, it has been corrected, madam, but in the application, madam, it wrongly has been
So give me
mentioned
liberty.
that this.
All the respondents have not been served. You have to. Is asserted from the office, and we'll just pass a direction, general direction that you put in fresh requisites for service of notice on the unserved respondent.
Lord, I am applied for one of the respondent, Omar Kumar Pal. Omar Kumar
Name, number
2.
no, 1-2.
Lord, the
Because 11 no traffic code is available. 13 AB no service. What is this application for?
Well, this is for appropriate order, madam. One injunction order has already been passed, my lord. The nature of the injunction order is such, my lord, that the parties are to be, my lord, maintain the status quo in respect of the food property as well as, my lord, from alienating and transferring the property. Now they are trying to change the nature and character of the food property. That is my case, my lord, in this application, my lord. For that reason, my lord, this application has been filed by us to pass a direction upon all the parties not to change the nature and character of.
If that injunction is already there, how can we improve upon it?
page 27 of the content, we have sent them a contact police.
What is the can number?
Well, this present can number
Present can-
is 4 of 2025.
Will not start, this can not start on my side.
Phone not sir. কোডটা কোথায় এখানে কোড দেখছি চলে আসবে
For the first time, I.
যেটা আসবে সেটা উপরে দিয়ে দাও। কোড দেখতে পাচ্ছি কোড কি একদম কোড দেখতে it order means what order?
Here, my lord, injunction.
No, we have already granted injunction. There is a question of superimposition of an.
Regard to, my lord, to maintain status quo, madam. Now they are trying to change the nature and character of the food property. For that
No,
reason, my lord,
we have granted status quo regarding nature character.
nature possession, my lord. Nature character possession, my lord.
Transferring, telling, alienating everything.
That is there, my
No,
lord.
nature character was not there.
No, my lord, nature character not.
Possession and selling transfer.
Yes, ma'am.
You want to add nature character.
Yes, ma'am. Page 15, paragraph number 12. The order, my lord.
We'll record that. We pass that on.
No, we file an objection. Why? We have sent them a contempt notice, Russell can take 27.
That is on the order already passed.
Yes.
27 contempt notice can only be on this.
Now that is the case, I am changing the nature and character.
That is made out in his affidavit on supported by. File an objection till then we grant nature character status quo. The appellant shall the leave is on the prayer of learned counsel for the appellants. Leave is granted to the appellants to rectify the cause title to incorporate the names of all the respondents. Question of next paragraph. Copies of the application bearing can 4 of 2025 shall be served on all the unserved respondents at the earliest, and receipts stroke affidavit of service in that regard shall be filed on the returnable date. Since the respondents seek to file affidavits in opposition to the application, comma, the respondents are directed to file such affidavit in opposition within a fortnight from date. Full stop. Reply finish shall be filed within a week thereafter. The application shall be listed next for hearing in the monthly list of February 2026. Full stop. The parties shall maintain status quo as regards nature and character of the suit property till disposal of the application.
One thing that before this the order was passed, they have complained in respect to the changing of nature and character. After that, no, nothing has been done. And when nature and character, I think only some repairing work has been done because they're running shop.
If you change that, you have to take the.
No, I have not changed, brother. That is also that recorded. I am not.
Put it in your opposition. We'll record everything. Give copies to all of them. We have put it receipt or affidavit service because we serve on the advocate receipt. If you serve on the client, then affidavit service. Ascertain who has not been served. And you check from the department if some of the notices of appeal have returned unserved. Just ask your clerk to ascertain and put in the specific. Put it in your order now.
My lord, can you consider once, my lord, page 15 of my application?
What have you stated there?
There is direction found by your lordship, my lord, appellant shall submit in due requisites for.
So that you have put in already.
That I have
That you
already
have.
put.
Very well. On the next occasion, if they still remain unanswered, then we'll pass it.
Item number 17 with 18.
17, my lord, I am for the appellant.
Yes, yes.
My lord, there was a direction of your lordship. My lord, I'll just, my lord, state the, my lord, facts first, my lord. Respondent number 1, 2, 3 has been, my lord, served properly, my lord, and it has, my lord, come back.
Yes. What
Now,
about
my lord, in the suit, my lord, when the decree was passed, my lord, the case was that, my lord, 1, 2, 3 are the co-sharers, and my lord, the remaining respondents, my lord, they were, my lord, the trespassers in the suit property. So they had nothing to do with the partition suit.
How can you say disjoinder of cause of action then?
My lord, in the suit itself, my lord, that is there. From the suit itself. Because it's a partition suit. Respondent number 4 to 10 were made part of the partition.
Then the suit is not maintained for disjoinder of causes of action. You cannot.
That is their suit, my lord, their suit.
You have described
Well, their suit, not my suit, my lord.
You have described yourself to plaintiff's appellants.
Yes. Your lordship is looking at, my lord. No, my lord, 2 suits were there. 2 suits, my lord, were my lord, hard analogously. Hard analogously, and my lord, one is their suit, the other one is my suit.
Both were
2
hard.
partition suits were there, my lord, in respect of, my lord, 2 schedules of property. 2 partition suits with respect of 2 schedules. My lord, I say that A, B, C, all the schedules of property are partable.
What happened by the impugned judgment? What was done? In the impugned judgment, what happened?
By the impugned judgment, my lord, their contention was, my lord, accepted that they were, my lord, they were the owners of a particular schedule.
Listen to us. Your suit has been dismissed.
No, yes, my suit, my lord, with respect of one of the schedule, the learned judge said that you do not have any right.
What about the other
with respect of one of the schedule of property?
Other schedule?
In respect of the other schedule, partition was granted.
Partition could not be
granted. So basically, their contention, my lord, was granted.
Partition.
No, my lord, what I'm praying before your lordship is, my lord, what I'm on before.
Partition could not be granted. Mr. Banerjee will not hear you unless you answer our question. Sorry.
Yes. My lord, there was some issues with the connection.
You cannot go on without answering our question. Sorry, we are very.
Yes, certainly, my lord, there was some issues with the connection.
Ask a specific question. You have to answer that first.
Yes, certainly.
The partition decree we passed at the first instance without passing a preliminary. You are saying partition decree was granted to you?
My lord, the preliminary decree was granted.
Say that.
Preliminary decree, my lord.
Yes, your condonation application is there. What about the other persons?
Yeah, my lord, what I, my lord, is what I am, my lord, saying before your lordship is, my lord, with respect to 1, 2, 3, my services, my lord, since, my lord, it was held that, my lord, the partition, they were the co-sharers, and, my lord, with 1, 2, 3, they have refused service. With respect to, my lord, I'll be candid, my lord, with 4 to 10, my lord, copy has not been served yet. My lord, if your lordship, my lord, directs me, my lord, I can serve to 4 to 10.
It transpires from the papers before us that although the respondent numbers 1 to 3 have been served, the rest of the respondents have not yet been served. Full stop, next para. Accordingly, the appellants shall serve copies of the applications afresh on the respondent numbers 4 to 10 and file a fresh affidavit of service on the returnable date. Full stop, let the applications be listed next in the monthly list of February 2026. Next.
Grateful, grateful.
Item number 19.
None appears for the parties at the time of call. Full stop. Let the matter stand adjourned and be listed next in the monthly list of February 2026.
Item number 20.
Yes. Why?
Since they have not paid any operational charges and subsequently execution was filed before the landed court below and
It has been executed. Have you got a copy of satisfaction of degree, that order?
right now I do not have
We'll put it in the list. It will retain its position in the list. We'll record a submission today. We'll request you to bring those papers. We'll put it on Tuesday. Tuesday. Can you get copies?
I'll ask my client to
Ask your client, because only the orders of satisfaction, recorded satisfaction. This is against eviction degree. None appears for the appellants at the time of call. Next para. Then counsel appearing for the plaintiffs to respondent submits that the applications have become infructuous since, pursuant to the impugned decree, execution was levied and the execution has already been effected by handing over possession of the suit property in favor of the respondents. Next para. Learned counsel for the respondents is requested to produce copies of the relevant orders of the executive court recording satisfaction of the decree on the returnable date. Accordingly, let the matter stand over till January 19, 2026. We'll give it 2 weeks. January 19. Appeal does not automatically become infructuous because section 140% is there. If they win the appeal, they can get that. If they say they don't want to proceed, then we'll drop it. Otherwise, we'll dismiss the application by recording your and direct them to put in paperwork.
Item number 21.
Yes. Appellate. One second.
Here, corrected all
The memorandum has been corrected for you. The other defects are also cured.
Yes.
Yes. What is the matter?
Here, it says, appellant is speak twice in a matrimonial suit where he knows someone is served to her.
Did you direct him to serve copy of these applications on the other side? Then we are directing to serve copies of both the applications and come back. How soon can you serve?
Only 7 days.
7 days you won't be able to. What does he decide? Kharagpur. At least 2 weeks. We'll put it after 2 weeks. Learned counsel for the appellant shall serve copies of all the applications as well as a copy of the memorandum of the appeal on the respondent, indicating that the application shall next be listed for hearing on January 19, 2026. Whose of the appellant shall file an affidavit of service to that effect on the return. We'll come back, we'll condemn the delay. What is the delay? About?
The delay about 300.
400 euros. So we'll have to consider.
Item number 22.
My Lord, Mr. Shobhan Mukherjee is attending for the appellant.
Mr.
Shobhan Mukherjee is attending for the appellant. Kindly make it due to his illness, he could not come.
You moved the matter, you are sufficiently competent.
I am not the advocate, I am not neither the chamber team.
Don't have local senate to ask for them.
Okay.
Okay. Remains up. Oh no, we have fixed it for a.
Interim order was vacated, then they asked for reimposition, they will reimpose the
Ah.
interim order, then again they did not appear. We have given a notice.
At the time of call, comma, an adjournment is sought on behalf of the appellant. Full stop. We find from the order dated January 5, 2026 that on the said occasion as well, comma, none had appeared for the appellant, although the respondents were represented by counsel. Full stop. As pointed out by learned counsel for the respondents, comma, due to non-appearance of the appellant, comma, the ad interim order granted initially had been vacated. Full stop. Thereafter, comma, reimposition of the same was sought and such stay was reimposed. Full stop. Again, comma, when the matter was called on for hearing, comma, the appellant did not appear. Full stop. Next para. We recorded in our order dated January 5, 2026, comma, accordingly, comma, that we were bent upon vacating the interim order again. But since a plea was taken in the application that the appellant comes from the marginalized sections of society, comma, we granted a last chance for the appellant to move the application. So, however, comma, it was made clear that in the event the appellant remains unrepresented on the next occasion, that is today, comma, we shall not show any further lenience and ex parte orders may be passed in the absence of the appellant. Full stop. Since the appellant chooses to remain unrepresented today as well, comma, and seeks an adjournment, comma, we have no other option but to dismiss the application for default. Which application can what is 4 and what is 5?
4 is for the interim order, temporary injunction,
And 5?
for opening a padlock, and 5 is the temporary injunction restraining us from creating third party.
Accordingly, can 4 of 2025 as well as can 5 of 2025 are dismissed for default without any orders to cost. Without any orders to cost. Please give your name only, not because you are asking for time on his only your name.
Item number 23.
Mr. Banerjee, is your learned junior related to you? You saw this Sunday every day we see the, I did not. Yes. Next matter, yes. Respondent. Yes. Last chance was given. By an order to
Hello, and for the appearance, hello.
we are going to dismiss the appeal. Came in the nick of time.
On last occasion,
You did not appear. On last occasion, you did not appear.
the official record before the Christmas vacation, we have been directed to serve a letter on the lower court advocate.
5th January, the matter was called on, but you were not there. He was there.
We have been
Now you are here, move the matter. Why waste
but
time?
the service is not completed yet.
On whom?
On the learned advocate, looking after the case in the lower court.
Then an advocate for which response? Plaintiff
For the
response.
applicant, madam.
For the appellant.
Yes, Your Worship. For the applicant, madam.
You are for the appellant.
I am for the applicant. We have been by Mr. Moses tragedy. Madam, on last occasion, when an application for condemnation of either was filed, we have been told to since there is a huge delay, so we have.
Mr. Monizam, when you are appearing for the plaintiff respondent. Yes, she is appearing. You are defendants in this trial court.
We were defendants.
They are appearing, so move the matter.
Well, there is a delay. There is a condemnation of delay application.
Move that application. What are you saying? We don't understand. You are taking up the application for hearing, it's appearing in the list.
Well,
On the last occasion, you did not appear, we gave you a last chance.
Mr. Fukushiki tragedy is appearing, madam.
You are not appearing. They will dismiss for default. We had given a last chance today.
Maybe possible. I'm getting in touch with you.
It's appeal for 5 minutes only. If it does not come, you move the matter. You are in the matter also.
I'm in the matter, madam.
Mr. Monizam, you don't have a copy of the application. No copy was given to you. The appellant seeks an adjournment to serve. Learned counsel for the respondent number 1 reiterates that no copy of the applications have been served on the respondent number 1. Which of next para? Since the plaintiff stroke respondent number 1 is the only contesting party, comma, the appellants are directed to serve copies of both the applications on the learned advocate representing the respondent number 1 today before us, comma, by tomorrow. Full stop. The applications shall be listed for hearing on January 13 to 26 next. Give copies by tomorrow, try to give by today. Ask him to give by
I'm
today.
just doing it right now, Madam.
Yes.
I will. Ready to you.
Give your appearance.
Item number 24.
Yes. Now, second judge's copy of reply.
I was
Now you are not in default. Right? Yes. This is occupation charges.
ex parte degree मतलब by 30 lakh ex parte degree of divorce. Can one is an application under section 5 of the Legal Act 509 is
Only. You have already remarried in the meantime, your client. Why didn't you remarry? You should have remarried so that it would be easier for us.
I will be
What is the reason for the
yes
ex parte degree?
ex parte degree not show not
You never appeared.
never saw
Yes, what is your opposition to this? Your allowed
Their entire application can one is full of loopholes.
What are the loopholes?
Yes, sir.
Let him fill up the loopholes, then.
Yes. Now, we are kindly comes to the memorandum of appeal because the merits of the application and merits first
No, need not be. But why are you placing the memorandum in the system?
because the date need to be seen.
What dates?
I was figured the date
Have you stated those dates in the
exactly in the application date wise. How Miller fraud was played on court, Miller have
You have stated in the application.
in the application itself.
Let him place the can one.
Yes.
Why is putting the memo?
Remember, because the orders need to be shown to your lordship.
If you have not annexed it to your application,
Yes, no, remove the entire order sheet.
give a copy of the At the time of moving the application, comma, learned counsel for the appellant seeks to rely on the memorandum of appeal. You are also relying on the reverse page, the dates of application.
No, only the order sheet.
Your lordship, the matter may be hard today. If it's not placing.
কি বললাম?
Because
Rely on the memorandum of appeal. Comma, to place reliance on the certified copies of the orders annexed thereto. However, comma, learned counsel for the respondent contends that no copy of the memorandum, comma, along with the certified copy of the order has been served on the respondent, which since the appellant seeks to rely on the memorandum and its annexures, comma, the appellant shall serve a copy of the memorandum along with the orders annexed thereto on the learned advocate appearing for the respondent during the course of the day. Course of next para, let the matter stand adjourned for the day. Affidavit in reply file to be kept. Memorandum, take out a photocopy and give it to her. What is the difficulty? There is something dubious about the.
There are so many markings.
Your lordship, let the matter be moved to the I'm ready. He need not place the order.
You're ready?
Yes,
But he placed the orders.
Not place the order. Let him place the.
I need
Because the you can order. Come again.
Item number 25.
another tape card.
Today, you put someone put that copy to give that copy to someone.
Like taken on.
Stated. You have to spend on a whitener. Do that and give her copy. But our copy should be without the whitener.
Certified copies are there. All the orders.
Next.
Item number 25.
I'm also responding. The last question we have to directly serve the respondent number by month. That is what face out. That is insufficient.
Oh, now service has been completed.
Not complicated. Insufficient access.
Again insufficient. Why don't we find out the address? Which respondent was not served?
Respondent number 5.
5.
Fourth one. Deep Jha.
Obviously, it's not applicant. I mean, we are from 1 to 3.
Fourth one.
Yes, sir.
So I can send notice to the learned
Your brother and son. So you appear for
1 to 3. Rituja is not my
Rituja, son of late Om Prakash Jha. So he is. Oh, your brother.
and one son.
Your brother.
Father.
Don't have good relation with your brother. Brother contact.
They are claiming. Actually, I don't know who Rituja is.
Oh,
but allegedly, the appellant, she is claiming to be the first wife of the deceased employee. And this is a claim in so
that is Om Prakash Jha. Acha, Rituja contested in the trial court.
Yes.
Contested.
Not contested, but
Let us check up. Let's check.
in part.
Because the day before yesterday, I had placed an
Srimati Rituja. Srimati Rituja is son of late Om Prakash Jha. Yes. How can Srimati Rituja be a son of Om Prakash?
Not daughter of mine.
A written son of everywhere. First, asset is Sri or Srimati. Ritu can be both. Generally Srimati, but can be both.
I think Rituja is for the male. Timothy not for that.
the day before yesterday, your lordship had vacated the interim order was passed because of suppression of certain material facts with her. And amended application was made by me. Categorically, paragraph 6.
Let them come. So they are not enjoying any interim order. Let them serve and come back. Affidavit of service filed today be kept on record. It appears that respondent 4 has not been duly served. Full stop. Next para. It transpires from the cause title that there is some confusion in the mind of the appellant as to the gender of the respondent number 4 as well. Full stop. Accordingly, the appellant, according to the learned advocate on record for the appellant, is granted leave to rectify the cause title of the memorandum and the pending applications, comma, depicting the correct gender of respondent number 4 and serve afresh on the said respondent. Full stop. A further affidavit of service shall be filed on the returnable date. Full stop. Let the applications be listed next in the monthly list of February 2026. It's just asserted male or female.
Yes.
We have given you liberty. Make the correction. Either daughter Srimati or Sri son.
Yes.
Rituja, the plaintiff. In the petition, she has been mentioned as she. So you check up and
Yes.
then son will be daughter. Do that. Nirmal. Nirmal. Nirmal Jha, Nirmala Jha, not paying you well.
Both parts.
What to
Period of material.
No, is it possible to mediate between you?
I spoke with my client. She's
Because if they are not
they are not aware of this person. And because one of the cases was filed in Patna High Court, where I asked them about their appearance because someone had appeared. My client said that they have not engaged any advocate in Patna High Court to deal with the matter. It's a serious consequence.
difficult to mediate.
Obliged.
Item number 26.
I appear for the response.
Yes.
But well, that matter where
We don't recall anything.
the
Believe-
probate
believe us.
proceeding and the probate proceeding, the point of the appellant was that once the issue had been framed formally,
Oh, there. Now,
yes,
who is appealing?
but there was
Refused. We have already heard the matter. We are about to decide it finally. We'll give them a last chance. Because we said that the appeal and the application shall be instituted. What is the ground? Why is he not here? Ask him.
When the trial,
Went to which tribunal? Which bench?
second.
For your truthfulness, you are adjourned. An adjournment is sought on behalf of the appellant, although the respondent is represented through counsel. Who's the next para? As a last chance to the appellant to move the appeal and the application, the same is adjourned for the day.
Item number 27.
And for the
Yes.
the application is we have paid for
Alimony. Yes.
and given an executive asset of
Every asset filed by you.
and reputable asset and all.
You are filing that now? You have filed your affidavit of asset. Mr. Ghosh, you have filed? You have already filed. Oh, yes. Reply? No reply.
But copy section 36 application was given to the I will
Not you, is a reply. Okay. Move your application. Mr. Paul, take your seat. We'll just hear him. His alimony application. Yeah, you are enjoying any stay order?
They don't see it because the divorce has been
Dismissed. Dismissed. Yes. Please take your seat. We'll just hear him.
brought the not kindly come to
Is there any child of the party, Mr. Ghosh?
No.
No child. Very good.
not kindly come to brought the page 17 of my application. Details of the order was passed by the trial court. The application under section 20.
8,000 per month was granted.
Okay. Then Lord kindly come to page 10 of the application.
That order was challenged.
That order was challenged, Lord, is only on the ground that he is the Anganwadi worker. She is the Anganwadi worker. Page 12, there is an observation.
Mr. Ghosh, Ms. Chakraborty appeared for the petitioner.
Previous matter. Before grant of divorce.
Mr. Paul, she's my relative. I should listen. Otherwise, you would never get any order from
I have
this.
assumed that may not take up the matter.
You would never get any order.
I will get down.
No, there will be a reverse bias. So therefore, don't take the risk. When the matter is being moved, comma, we find that Ms. Chakraborty, comma, the relatives of one of us, bracket আমার নামটা পুরো, appeared at one stage of the matter on behalf of the present appellant. So, sir, accordingly, comma, for the sake of judicial propriety, comma, we are of the opinion that this bench should not take up the matter. So, sir, accordingly, the matter is released from our list on the personal ground of one of us, আবার আমার নাম, bracketed. We'll devote it to the parties to approach the Honorable, the Acting Chief Justice, for assignment before a division bench. Before a different bench. Sorry.
Let direction be given for supply of the affidavit of assets upon.
No direction is needed. This Paul is there.
Item number 28.
Before you rush to takes Article 20, doesn't switch for Article 25 is concerned. Because I submitted that the interim order was vacated, I find that the motion had observed that it entitles the respondents for vacating the.
But did not.
Was not. That the teacher lordship to grant part.
No, on the next occasion. You have passed an order. On the next occasion, just
The
forward.
matter will remain pending thereafter, your lordship.
No, it will remain in there. It will come in the list. We have already passed an order. We have taken up another matter after that.
So based on my submission that an interim order has been taken.
Forward on the next matter. Yes.
Item number 28.
Under the responsible order, they are paying for making the order actual.
What is the matter? What does it arise out of?
My lord, well, I am a chief attendant, my lord, the other of the.
No reply. You will not file any reply.
I think that's filed.
I'm the plaintiff applicant matter. I filed a suit stating alleging that the father of the defendant number one was the Bharatiya under me. Father died, and defendant number one he is residing at Odisha, and he was trying to transfer possession of the property to the defendant number two. Defendant number one and two did not file written statement. And minor was dismissed on the ground that I have not paid for dealing or for eviction. Section 34 minor they took the point. So I say minor that trying to sublet is not ground for recovery of possession or for to file suit for eviction. My case is that defendant one was trying to sublet, and defendant number one did not contest the suit by filing petition, not defendant number two also agreed to the petition.
That was the only ground on which
Only that is the only ground.
the instruction will dispose of the appeal. Why?
I have to submit additional people.
Mr. Chakravarti, please give the copy of the
Because
memo.
we had filed, the defendant number two had filed written statement. We had filed written statement. We had cross-examined the plaintiff.
No.
also.
Oh,
Not
achha.
adduced evidence.
We have not reduced evidence. We only.
And
we
he
did not
proposed minor.
Milord, what has happened?
No, but if it was dismissed only on the ground of section 34.
Milord, why I tell you, Milord? I tell my lordship. why.
Yes, yes.
Originally, the plaint was filed for a declaration that the defendant number one is an occupier in respect to the suit property, which is admittedly a thika-tenanted property. Along with that, a permanent injunction prayer was there, as well as a prayer for recovery of possession. Thereafter, by their own will, they amended the plaint. They took out the prayer for recovery of possession. Only the declaration prayer was there, and an amended.
So how can you be agreed with it? That they took away the recovery?
No, I am not agreed, but initially they prayed for recovery of possession.
If initially they prayed
Yes.
and then they withdrew that prayer,
Yes.
they are entitled to relinquish one of the reliefs.
Yes.
As per the civil procedure code, they are entitled to relinquish any of the reliefs.
But there.
But then, the question is whether the suit becomes bad by application of proviso to section 34. That is the only question.
Yes, Milord.
I may very well not want eviction of a particular person who is residing in my property, but merely pay for permanent injunction restraining him or her from transferring the property. What is the bar in that?
Milord, there were two grounds.
Why should it be? No, court has not adjudicated on merits. That is what we are saying.
The court has, Milord.
Let us come
The
to
court
the
has
judgment.
on two grounds.
Come to the infinite judgment.
I don't have the memorandum of appeal.
You must have a judgment, the copy of the judgment. Whenever,
I don't have the copy.
why did you
If
have?
I can-
When you took instruction from your client, the first thing you want is a copy of the judgment which you are defending. Why should they give it to you? Their application they will give to you, but your judgment should be with you.
I don't have.
If you don't have a judgment, how do you know that it was
Milord, actually, I was there before the trial court arguing the matter.
No, it appears only on the ground of section 34. Only on section 34. Mr. Chakravarti, give a copy of the memo along with the judgment to him. Come prepared. You are just adjourning for the day.
I do.
In view of the short conspectus of the appeal, since apparently the learned trial judge dismissed the suit filed by the plaintiff's appellants only on the grounds of bar under the proviso to section 34 of the Specific Relief Act 1963, we intend to take up the appeal along with the application. First, sir, the affidavit in opposition filed to be kept on record. First, sir, to enable the learned advocate for the respondents to come prepared in the appeal, the appellants shall serve a copy of the memorandum of appeal along with a copy of the impugned judgment and decree on the learned advocate for the respondents during the course of the day. First up, the matter is adjourned for the day. For the day is tomorrow, probably we take up. No, the matter is adjourned and shall next be listed on January 13, 2026.
I'm waiting only for the respondent number 2.
যেটা বললাম সেটা respondent number 2 হবে. What about respondent number 1? They contested in the trial court. You check up Mr. Chakravarti and you also check up from the judgment whether they contest. Did not contest? Yes.
Item number 29.
Which Mr. Rahul Kormakar? Every matter which you fix the appeal along with the application, the advocate 6 times. Why? You stop fixing appeals along. You are the chamber junior of Mr. Kormakar. So you should be prepared with the matter preliminary. You should have a brief. How long have you joined practice? 3 years. You give a copy, your copy to him, we'll pass you over for 10 minutes. We'll take it up after that. We'll move the matter. Don't escape with the copy. You leave it. Yes. Next.
Item number 30.
Yes, Mr.
There is an appeal that has been referred by one of the employer filing a suit against the employee for not adhering to the terms and conditions of the appointment. So there are two breaches that has been committed by the employee. One is that he was supposed to serve a notice of 30 days.
1 second. Specifically fact. Please continue, sir. We have given you a clue.
It's not falling within the bar of 14 or 16.
That is exactly what. Anyway, please continue. Yes.
There are two covenants.
Not adhering to, he has left your service.
Left my service.
Competing business.
Competing business, that is one. Another is that he left without serving a proper 30 days notice. In case if you do not serve the proper 30 days notice, there is a remedy clause that you have to pay an amount of damages.
There you remedialize in the government.
But the other part. So there were two aspects. My lord has already considered and passed the interim order wherein the respondent has been restrained from joining or continuing service with any kind of competing business because that terms provided. Now, my lord, after that I have duly served. On last occasion, my learned senior friend entered appearance and he took a point. Subject to correction if he still takes that point. Is section 27 of the So, my lord, I was
Contact actor. Yes.
So, since my lord has already heard me on the first occasion and passed an interim order which I have enjoyed. So now this is the only stumbling block which I have to satisfy my lord. But I will receive my lord. If my learned senior friend addressed on 27, then it would be easier for me to reply. So this is the short background. If my learned senior friend
Yes, sir. Probably that will be the
easier way to
because he'll be there.
We come to page 27 of the application. The appointment letter.
Yes.
Yeah. Date is valid 1st of March 2023.
Right.
The clause in probation. Will be in probation for a period of 12 months from the date of employment. The probation period can be extended further by the company by a period of another 12 months. It is expressly clarified that there will be no automatic confirmation of the service even after the expiry of probation period unless management confirms the service in writing. There shall be no delay. Therefore, initial appointment was on probation for 1 year. Now, the management basing on 3 clauses, clause 11, 12, and 15.3. Page 31. You know?
Yes. 11, 12, 15.
11, 12, and 15.3. So for 11 and 12, my lord, these are my lord non-competing and my lord non-soliciting. These are my lord, maybe taken into consideration for the purpose of granting of voluntary immunity. So for the 15.3 is concerned, it is my lord relating to damage of 3 lakhs.
That we have made it clear, more or less, that
In track.
remedialized elsewhere. Yes.
Now, my lord, kindly come to page 39. This my lord is better, whereby, according to them, my service has been confirmed after 1 year.
Yes.
It is dated 1st of March 2024. Second paragraph. Following the satisfactory review of your performance during this period, we are dedicated to confirm. We are delighted to confirm your appointment as a permanent employee in the position of service manager with effect from September. But I am disputing this first because my service has never been confirmed. I was. my
You're
probation period-
disputing the existence of this letter.
Yes. It is manufactured document.
Have you filed any opposition to it? Did you directly?
Refused. Challenging that appeal has been.
No, in this.
No, I
before-
have not. But Manoj, I shall show from the records. Well, this is their contribution that my service has been found. Now, my lord, kindly come to.
No, Mr. Mahato, if you want, we can permit you to file opposition and bring it all later.
Well, if that.
Otherwise, after hearing, we won't permit you that.
No, well, I said, just manner, as before coming to section 27, I am just.
No, Mr. Mahato, we are making it clear that you have to argue.
From
We are
their
hearing the
document,
injunction.
it is contrary.
If
From
you are
their
confident on that, then yes.
From
But
their
if you,
document.
but even if you fail after hearing, if you find that you have not made out a case, then we won't grant you further opportunity to file an application.
No, my lord,
Because there cannot be two
that's-
hearings.
that I have-
We are very hard pressed with that.
my lord,
Either you come up
I
with
shall
a
not take much time.
no, you take as much time, Mr. Mahato, for hearing. But you have to choose. If you say that you won't file an affidavit of opposition, we'll record that learned counsel does
My
not.
lord, I shall file the opposition, your document is with me. I am to.
Then you
dispute
can
that.
file it. We'll give you 1 week
If
time.
it is my lord found, that's section
No,
27.
that chance after hearing you say that no, now I'll file.
Not all, only section 27. Whether
That is the crux of this matter.
whether the agreement at all
No,
is,
Mr. Mahato, either you file your opposition, we'll hear it.
then my lord, I shall file.
File it. If you have the document, how should you file? Tell us how should
But
we.
section 27, my lord, agreement is void.
We'll take into consideration everything.
My lord, kindly
Side
take
way.
1 week time.
Very well. The respondent shall file an affidavit in opposition to the injunction application within January 13, 2026, which the reply, if any, shall be filed within January 19, 2026. The application shall next be listed for hearing on January 21, 2026. Thank you. Comprehensively, we hear out the dispose of the injunction. If you succeed in your point, succeed in all your points.
Item number 31.
You all have it.
Because I am entering on behalf of the respondents to the matter.
Yes, Mr. Chapu. Yes. You have the appeal.
This is my appeal. The minor was pleased to grant an ex parte identity order of injunction.
What is the nature of the suit?
But the nature of the suit is a suit for declaration. I'm a tenant. There was a tripartite contract between me, the landlord, as well as the developer. The contract specifies specifically that I will be given a particular place for my residence, alternate accommodation, as well as I will be given a place after the construction is completed. I will reinstate. Without doing that, they went on and started carrying on the construction. I went on and filed a suit before the.
There was a written agreement.
Written agreement. Notarized, but written agreement.
You seek a specific preference of that.
No, but I made a declaration that the defendant shall not act in breach of the agreement.
All right.
And not to evict the people.
And the injunction is that they would retain a portion.
No, the injunction that was granted by this honorable court was that they were restricted from putting up the construction in the suit property, and so long as the application is and not to change the natural land. And my possession.
Construction has been completed.
No. They are just.
So then how can you apprehend that they will not?
No, they have started demolishing the building and they have started demolishing my property where I am in possession. Right?
No, the agreement was that you will be retaining your portion or they'll give a new portion to you after demolishing your.
They will, in the building plan, they will chop out my specific portion which I will be given. After that is given up to my satisfaction, then the construction will start.
So it will start after that.
After that, nothing will start. Let me start.
Yes. Yes, Mr. Rai.
Things, my lord, shall you turn to the agreement once? That your lordship will find at page 60 of my application.
Yes.
And when was the clause 1? So it is admitted that I will operate as the portion decision test. Apart from that, you will logically consider whereas the second party, the disposition portion, the same page is a lawful tenant, fine. Under the first party restricted room on ground floor of the premises of a successor, on the basis of monthly rent of 1,200 per month payable to the first parties and the second party, according to the English calendar month, the same tenant room is still continuing its use, possession, and occupation of the second party under the ownership of the first party. It is being used as a kitchen for official business, second party, with consent and permission of the first party. Now, I will turn to the second clause. The third party's developer will make construction of new building at the same time according to sanction plan to be obtained from the Calcutta corporation on mutual undertaking. The developer and promoter being the third party will make construction of new building given the position of the second party tenant for the same area of tenanted room on the ground floor of the same premises.
That is after making the construction.
You have to earmark when you obtain a plan sanction plan, you have to indicate when you are rehabilitated the tenant is for that premise.
Not necessarily. It is no agreement. If you agree to vacate the premises, it's not
No, it is vacate the premises on the premises that he will give sufficient accommodation that
probably clause 1 is more beneficial to you. You are skipping over why are you so?
I've brought a notion that I am the existing tenant and also
No, clause
sufficient
1,
accommodation
number 1.
and sufficient accommodation.
Please, clause number 1.
Yes.
In its entirety.
New building, that the third party and the third parties will cooperate. The second party for vacating the ground floor, such tenanted room measuring about 7,000 square feet to enable the first parties and the third parties for construction of new building and developing the existing structure and during the period of construction. New building, the second party to given sufficient accommodation in the same locality and the cost of third party to be paid rupees 50,000 per month and the second party according to his desire and requirement with the said cost make arrangement for shifting his accommodation and the tenanted room.
This is the clause which you are now at this stage you can, because the accommodation can be given after the newly constructed building only after. So now during the period of construction, the second party to be given sufficient accommodation. You have not been given a sufficient accommodation.
No, nothing. Apart from the cost of the third, if you are looking at consider clause 8.
Even if you take clause 3,
Yeah.
give possession to the second party for the same area of tenancy on the ground floor. So why should it be earmarked which portion will be given to you?
Yes.
They can construct ground floor in their own way. Their only liability is to give you a similar place.
What is
Why should it be earmarked that which portion in the plan?
You are not in the plan because now under the magistrate building the rules. It says the ground floor is if it is a more than 2-story building, the ground floor for the purpose of car parking space.
So then this is a non-starter. It's impossible to perform that.
That is why now for the purpose of rehabilitation of the existing tenant, there is a provision made by under the Government Business Corporation rules that yes, you can get extra land and also relaxations over this providing this car park business, provided you have to indicate in the plan where you are according to the tenant, existing tenant.
Yeah, previously in your plan, these things.
No, here man is because they are did not neither the sanction plan nor because the one day started demolition of the building. That is the case. If your Russia can turn to the claim itself. Paragraph 7. Page 38 paragraph 7.
Yes.
Turn to paragraph 12. Also. Hmm.
The only thing which you find that if you have not been given alternative accommodation, you can think about that. But this earmarking, sanction plan, corporation rules, you have to plead something in that on that count, or there should be something in the agreement. Because this is a new pleading you are setting up. Yes, you need not plead law. You understand that. But at least you have to put in the rudiments, the factual rudiments in the plain.
Because we are not.
That will be the premise of the law. Because you take a new plea here before us, which is not in the plain. That although I agreed to the ground floor cannot be given under the law. If to be given, then sanction plan has to mention that these things are not there at all in the plain. You simply in the agreement you agree, they agree to give you a commensurate portion in the ground floor and to give you alternative accommodation during construction. Now they have started construction demolition work,
Without
not giving you alternative, and there is nothing for us to ascertain what I mean. This your other.
And if your lordship can turn to paragraph
Mr. Rai, I have another bench actually. Division. So pre-judgment with Justice Banerjee, that matter. So to rise right now. We'll take up continue with this matter on the next day.
before Thursday.
To be in the list whenever we can reach. Thursday general hearing matters.
Yes, that is right.
Maybe not.
Then wait.
Although the matter is taken up for at order. Although the matter is taken up for hearing, due to paucity of time, the hearing cannot be concluded. So accordingly, the matter stand adjourned for the day.
Before minor rises.
We have reason. Yes, what?
I could not reach the interim order was extended, but this was an eviction decree matter.
Sorry. You have missed the bus. Proverbially.
This appeared.
Yes, Mr. Pal.
Before yesterday, this only for body was
Okay.
not. I will recall that.
We did what? Dispose of the.
No, already. Next matter.
Next matter.
We are in 31.
When
Item number 2 will kindly appreciate. This was called